Yes. Fresh mat. Kodi, fresh mat is good. Extension. Monday. Tomorrow. Yes. Tomorrow. No delivery tomorrow. 2:30. Good. Just wait.
Page number 2, 11 to 23. Page number 4. Page number 3, 24 to 33.
32. 30. At tomorrow. Relist the matter. No, office objections compliance and there. Huh? Any urgency? And tomorrow.
Page number 4, 34 to 35, 34 and 35. Page number 5, 36.
You have informed the other side. Correct. In my court, you must inform in advance to the other side. Ask him to inform him, and then you must report to the court office. Yes, mark. IO extended till next date. This the matter next week.
6, page number 6, 37 to 44.
Have you informed the other side? You must inform in advance, and then inform the court office. Inform the court office next week. IO is extended till next. Yes. This matter on Monday.
Page number 7, 45 to 50. Number 8. Page number 9, 55 to 60. 10, 61 to 64.
Kodi.
This matter serial number 1.
You take out notice. Issue notice, same on.
Number 2.
CRP should be filed against the impugned order. You have claimed judgment on admission. Why not? Then you are claiming, no. You are what is the relief? Judgment on admission. Correct. The proceedings will come to an end as regards such of the respondents. CPC could see. Or other proceedings. Food or other. We take out notice. You take out notice. You take out notice. After they appear, we'll see. Revenue record is in whose names? Revenue record is in his name. Correct. Now we take out notice, we'll have it week after next. In their presence, we'll see what entry model. List the matter week after next. Consideration of interim pays kept open. Let us see until the election matter gets over. Yes. Okay. Pass over. More than that. Take out notice. Emergent notice, and you're permitted to serve trial court counsel.
Yes.
Let us. You take out notice. Issue notice. Let us see. Court says that the amendment is for the purpose of removal of discrepancies. Let us see. You take out. Same one. Note on it.
9. Number 9.
Yes. Password.
10.
Appear for petitioner in this case, my lord.
Yes.
The petitioner being highly aggrieved by the order dated 17/12/2012, my lord, by rejecting the impleading application filed in OS number 201/2016.
What is the stage? What is the stage of the suit?
Stage, the evidence is over and the matter was posted for arguments, my lord. At that particular point,
Arguments on the main suit.
at that particular point of time, the petitioner came to know of the pendency of the suit in respect to the same property, my lord, which the petitioner is the owner. And the respondent number 1 has filed the suit against the respondent number 1 and 2 for declaration in respect to the property which belonged to the petitioner in this case, my lord. He, after having come to know of the said fact, he filed impleading application and that came to be rejected, my lord, without appreciating the facts, my lord. And without
You are a purchaser prior to the suit or after the suit?
he has purchased in the year 1985, my lord. Petitioner has purchased
85. Yes, you have produced the sale deed. Have you produced?
Yes, my lord. Yes, my lord. And he has also filed one more suit.
Annexure? No. Annexure, sale deed?
Sale deed we have not produced, my lord, but we have produced the certified copy of the order and this impleading of certified copy of the impleading application and certified copy of the objection statement filed, my lord.
In light of contention raised by the petitioner that he is a purchaser of property prior to the institution of the suit, and the trial court has grossly erred in rejecting the impleading application, there would be stay of further proceedings in the suit till the next day. You should note the same one.
The proceedings were pending.
I've stayed it.
Please, my lord. Please. Oblige.
It appears to be a correct position that legal representative cannot go beyond the
Yes, but the application is not the pleading and independently permission to stated.
But how can you withdraw an admission?
This child was stated as the without disclosing the two facts on behalf of the parent and the court signatures.
Let us see. We'll hear the matter, but we'll have to stay it. We'll hear the matter. We'll hear it and then we'll see what will happen. Great. When is the next date? So we'll stay the. Huh? What is the stage of the suit?
Already doing the lengthening of
Proceedings before the trial court to be deferred till the next date. List the matter week after next. Give it to file objections, if any, by next week. Learned counsel, so and so, undertakes to file for colors for R2 and R3. Yes. Now status quo order is passed. You serve them and then we'll see what is to be. Let us see. No, so no, let us see. We'll hear. We'll hear the other side. And then order is passed on 18th August 22. And have it week after next. You serve the other side and keep consideration of interim prayer open. Now, since it's an order against an MA, you have to hear both sides on the order passed on the IA, MA, and then see what is to be done. That is week after next. Same order. There is order of status quo operating since August. And have it week after next. Let us notice the same order. List the matter week after next. Consideration of interim players kept out. Yes. What is the delay? 6 years. How do you explain that?
But we are fighting for the very sake of. But we purchased it from for and I have purchased from. I saw I am in position.
Right of, what is the stage of the suit?
This is not for
On the main.
because the other evidence, those they are not. I am the only. Therefore, as I did not.
Right of the submission. Other dependents have not filed. They have not filed written statement. Later the state the submission that the other dependents have not filed any written statements. And the written statement filed by the petitioner has been rejected as having been filed belated. And the matter now is set down for arguments on the main petition. There will be stay of proceedings before the time to the next. Notice. Notice to respondents 2 to 5 dispense with at the risk of the petitioner in light of the memo file. Yes. This along with WP number so and so. Right. Yes. Now injunction against whom? But why have you made the bank as a party?
They are exporting various countries. There are commitments there. They have to repay the loan, but because of the circumstances,
No, but at least we serve the bank with here. No, let us see what is the stand of the bank, and then we will see what it is. We'll have it next week. You serve on the standing council for the bank and hear them, and then we'll decide any grant of any incentive. Why have you made the bank a party? That we'll see. Without hearing the bank, I am not going to pass ex parte order. That we'll see. I want to know what the stand of the bank is. If they have already initiated proceedings under surface, then we cannot interfere. Let us see. Let the bank come. You will have it next week. You serve the standing council for the bank. Let them get instruction. Then I'll decide. No. Without knowing the status from the bank, I'm not going to pass any order. Without hearing the bank, I'm not going to pass any order. Let us see. You serve them. We'll have it next week. We'll have it. Without hearing the bank, I'm not going to pass any. No. Without hearing the bank, I'm not going to pass it. We'll have it next week. You serve the standing council. I am not going to pass any order without hearing the bank. You serve the standing council for the bank. in their presence until next week we'll have. Issue notice. The petitioners at same order. Issue notice, same order. Petitioners at liberty to serve the standing counsel for the second respondent bank. Consideration of interim prayer is kept open. This is the matter next week. No. That we'll see. That we'll see. You serve the bank and then you date. Yes. So,
Differently, as well as the amplified.
now this matter we can't grant any ex parte order. They will serve the other side and we'll hear. Oh.
Who should have the
No, that's right. No ex parte order. I'm not going to. So I'm saying you serve the other side. We'll have it. Yes.
Consequently, I am find presentation I did the development was clear and accounted. It's pending and plus counted only burning up. I am the it was not. Therefore, it should be better for to be granted. It's 90%, only percent is interim order that.
So we'll have it next week. You serve the other side. We'll hear both. And then
I will finish part of that. Because the
you are the secretary of court. I said there is no evidence regarding ownership of land in the trust.
just them, I tell government is not we have made enough land. But
No, the plaintiff is also performing, is carrying out the development work. No, that we can't decide now without hearing the other side. How can we hear? How can we pass ex parte order in this case?
I'm not the interim order. I mean,
They only are performing future works. They will say. You are saying you have to perform. Who has to perform?
in my suit, the report of granted. I was not challenged by the plaintiff.
Let us see. Let us see. In the presence of the other side, we will work out some arrangement. Because finally, who is going to perform puja? Either you or him, or by turns, we'll work out some arrangement. There's no point in both of you.
Nowhere in the court says that plaintiff is not performing.
That we'll see. Otherwise, I'll order for the temple to be shut down. Then both of you will be happy, and we'll order for the temple to be shut down. God will take care of himself. You will have it next week. I don't want to pass one more order and create more confusion in this already when there's enough confusion. Both of you, no, both of you work out some arrangement. You can't keep fighting of worshipping regarding a temple like this. What is this fighting about God?
I'm not.
So that's why both of you let them. That we will let them come and hear both, and we'll pass some equitable order so that at least till the suit is decided, there is no fight. I don't want any blood to flow in the name of God. You should notice same order. Consideration of interim prayer is kept open. list the matter on date. You both try to have some arrangement. At least half of you do some 3 days, he does 4 days, or try to have some arrangement till the matter is decided. Yes. But you did not file any written statement.
No.
Hmm.
The moment I filed an application for improvement, they are filing an application, for requirement. Question of me filing a letter statement, not come at all, yes, the state did not come. This is a law. They are filing a memo, because can you get permission fee?
So now the only point is, unless the other plaintiff consents, how can you amend his claim?
What is happening?
No, that's there. What I'm saying, plaint is filed by the other plaintiff. Now, if he objects, then you can't. How you can amend his plaint when you have two plaintiffs?
Any court regarding all the what is there?
No, but how can we have two plaints? Oh, it is a problem. Suppose you were allowed to continue as a defendant and permitted.
If I get transferred myself as a defendant,
No, that is, no, then we'll see. But that appears to be the only remedy. Now, for you, there is no written statement and there is no plaint also, as on date. As on date. As on date.
Family is not. I must come and.
No, but how are you going to solve this problem? How can we have two plaints?
He understood or no. Because the matter is separate for it. He also makes some decisions on that.
Otherwise, otherwise, you think about it, you keep a separate suit ready.
But what I would suggest to the my plan won't they will not be able to launch. If I want to I've done research on this because I did not get any. It says that what is the rate of every judgment says that income of the rates. But only proceedings, I only make what rate.
And the other plaintiff is objective.
That is only the issue that is why what I would respect is matter is set down for evidence. So now I need to lead evidence because the plaintiff will not lead evidence. So your option for the time being I am still so that I can that I can file a and I can continue.
Or consider filing a separate suit and then clubbing it with this suit.
That's the reason that I would request your last.
It is in light of the contention of the plaintiff that his proposal to file an additional claim nor has not been allowed, nor any liberty granted to amend the plaint, and accordingly, he is not in a position to place before the court his stand, subject to further consideration. The stay of proceedings before the trial court to the next week. Now your request to file additional plaint. What happened to that?
I find additional claim. The court said that there is no problem. Not
Rejected.
But I think because there is no issue. What I want it is such also said that I need to collect the worst is I need
to think about it. Mr. Matter week after next. Interim order will be enforced in the next week. Yes.
BJP is the party. But there are about 80 residents of the because just like of this
What is your relationship with the plaintiff?
taking was previous one.
They have sold.
They have sold the property. Yes. And something in the second person. Layout is so locality and sold it to these. Now they are saying that there is property belongs to them.
Now the sites that are formed are part of survey number 67. All the sites.
Number 67.
66/1 and 67 other two A and B schedule. So the sites that are formed, part of it falls under 67. You appear for the plaintiff. No, is it a fact that you have sold property and sites have been? Where is that decree? No, you have a copy of that. Are there, is that survey number vacant land? Full. Correct. Now, whether they have some interest or right is a question to be decided. If sites have been, sale deeds are executed in some of the scheduled property, either A schedule or B schedule property, then they have a right to see. That is a matter to be decided in trial. So that is a matter to be decided in trial. How can you prevent him from being impleaded as a party? No, but that is a matter to be decided in trial, not at this stage of impleading. Let us see. Let us see. Let us. I will notice same order. This is the matter along with the WP number. Yes. You are the.
The page number 28, spot number 1, they approach Assistant Commissioner under the Senior Citizens and Welfare Act. Then they ask question. The Assistant Commissioner directs me to deposit warrants.
Petitioner is your mother.
Petitioner number 1 and 2.
No. The Gaurama is.
Petitioner number 1 and 2.
What is the order now?
Page number 29, Assistant Commissioner. She is being transferred into her. She did not report this order. There is space. petition was filed on 24/9/2020 on page number 16. For which I filed my written statement, proceedings were going on. This juncture, page number 33, annex D. She files an application on the 150 maintenance charge.
Let us see, you take out notice, we'll have it week after next in their presence. We'll see what order to give.
The only endeavor is the section, whether or not the senior citizens usually for enforcement. It is not that it cannot be enforced.
No, but, no, correct, but this is a independent proceeding.
Partition.
Correct. So where is the bar for passing an order under in the OS 157?
Can pass, but however, this order have been considered, the execution of the previous order of maintenance. It has not been implemented for more than 1 year.
Let us see, you take out notice.
And in fact, I have not made any appeal challenging that order yet. The assistant commissioner's order.
But that is not enforced even according to.
It is not, they are not enforced. Instead of enforcing that, they come and file a application partition.
Let us week after next we have it. You serve the other side. We'll see what is to tell. Yes. Emergent notice to you respond. Same order. This is the matter week after next. Consideration of incident.
Yes.
Yes.
Now you take out notice. The order you have challenged is one now. Production of document.
They have challenged an order of, they have asked for an amendment.
Read that order, let us. From page 23.
I'll read the reasons.
Yes.
When the authorities deal with the property, they don't get the authority. On reading the amended statement, has provide declaration in the form number 7 of the grant of this. Third, partition of this. This will not. First,
You have a copy of the judgment.
Yes.
Oh. Page 85. Which para? Let us see. Now you complete reading. You complete reading the order.
The notarized has just occupied. Block number the person To the person allotting 4/6 of joint right to them and the newly constituted house. Number one, having taken defense the relative not each one of them having the third right not worship the third day of the worship the worship the third right the brain schedule property. I'm of the opinion that the amendment is to provide the portion of the of the party. The partition suit. Under section 48A of Karnataka Act of
Pen. Other pen. Yes.
Subject to further consideration in light of the contention that the finding of the trial court when the defendant cannot be allowed to take an inconsistent plea in the written statement is contrary to law. There will be stay of further proceedings before the trial court in the next week. Date of yes, now you tell me the facts. Yes, please.
Was disposed on 30 August 2004.
You are the decree holder. Date of 99.
Date of 1999. And that suit has been declared on 30th August 2004.
Yes.
And against which know that the respondent has prepared an appeal for the lower appellate court and as well as the sub-level court number for the attempts of dismissal. Thereafter know that we have filed an affidavit number 3 of 2004. In the year of 2012, right, this respondent here in Mother filed 2 applications.
Respondent JDR.
Not JDR, Ramchandra.
So he's a
JDR,
he filed
2 applications. Item number 23 and 24. Under section 3 and 4 of the Partition Act.
partition.
Of the applications of
All 2000 dollars. What the applications are rejected?
12th October.
$2,000. I can choose for that this respondent has prepared and read
WP number.
number of that as you can see that 7476
Page
page 26 this is
17.4.
17,476 115.
Yes.
That was disposed on 12th April 2021. So Partition can be seen page 27.
Yes.
That this land has that dispose of the writ petition. The writ petition is disposal of liberated right in the terms of force and adjustment, more particularly paragraph 27. That is annexed agreement.
It is only insofar as the aspect of dwelling house is concerned.
Dwelling house is concerned. Here is not that, it is not only dwelling house. There are two commercial shops.
No, let us see. And then what happened?
This judgment letters are filed as AL number 5. Under section 3 and 4 of the Partition Act.
Yes.
And this petitioners have filed detailed statement of objection.
Now the order that is challenged is the order.
AL number 35 on the challenge.
Read that. Read that order.
It is based on the AL number 35.
This is the impugned order.
This is the
Okay, read it.
the respondents have filed petition under section 151 of the Act which and for Partition Act, seeking permission to deposit consideration amount of ₹4,10,000 by deducting their 1/3 share. The counsel for the petitioners filed the affidavit annexed to AL number is now compared for the function of the property as it was not feasible for the division. As per their request, the court approved the sale of property by executive valuation. The spot sale was carried out on 4,000. The court sale was fixed on 19 It was not conducted on this day or on this day. Subsequently, one newly offered to purchase the share property for 4,10,000 was accepted by the court. Accordingly, property was sold and includes sales company. Approved by the state, the respondent have prepared an appeal for the appellant. The sale appeal was and directed to.
So this is in the.
Item number 17. Is the amended agreement. Petition number 11/6. 2022. Petition number 11/6/2011.
Okay. Yeah, yes.
Subsequently, the respondent of their total share in this of the sale of the share property. The respondent of one the same application is rejected by this court. But order. Approved by the sale order, the respondent of prepared and appeal to the control. The same appeal was allowed by this animal. It is further directed in law. And to favor the of the residue for the entration by the exponent. This is very important.
How did this date come? That's a wrong. No, correct. Now, the only question is when you are seeking rights under the Partition Act, what is the legal date to be taken note of for valuation? Other- No, otherwise, just wait. We'll finish reading and we'll come back.
To be determined after taking assistance of expert at the cost of the both side. Other directed that contesting necessary convention for the spectator at their own cost. Other directed that both shall have all powers in direction as in the required part within the petitioner to operated petition and submitted that may be permitted to retain. Asked in West and very much. And mine has been there by the trial. Responded or
Speak.
He has submitted the report stating that said property is not in that. A small sale was conducted at 142 and court sale was taken on 1942. Court sale was not conducted. Was highest bidder. But what has executed the sale amount was running for the exponent, which was allowed by the second of the sale. Other direction from Yes, because conditions are appointed for this. And we will so the report and photographs are yes, yes, it's better that the source of property very all and out of this just create and bio and not so even a hack. There is existed doesn't know. The remaining portion is written and it is randomly assigned to this one and The days for valuation not be reached on for. Like 10,000. The date amount exceeded for. Current amount. Payment of the share will be. This is not correspondent as relied on the judgment of. And so, where in it is because this is yes. Application. This is the important. At the time of making the application number 60, by approved by credit. Slide. Here was 11 and one sale was based on 9 people. You know, the respondent never made any application. But any review from there they have a right to buy purchase assured and prescribed. Subsequently, the respondent of an application IA number 23 5 6 and under section 4 and IA number 21 24 on 3 years ago. Right of the said application period 2000 for preemption or for sale of a property. He might is punished. And instead, they are claiming their total estate is covered. The application filed by the respondent I for analysis. For the rendition of the respondent payment of the as in 140. The date of calculation of the valuation is.
No, I don't know. At least some common sense in it. What I'm saying, some normal human being will understand. When you say covered by, it doesn't mean you have to take the facts of that case.
This
Correct. So now let us come back. Now, IA 35 is to be reconsidered.
The petition laws.
No, now the only point is IA 35 has to be reconsidered.
The time of then the right word approved how can currently so responding to the point 18 to 23 all 5 6 should be applied. That was the end of that was in previous options.
Just show me the drill.
Partition, how assessed. Is not done. And they can find fixing the valuation after an application period. Yes. Value. This is the important.
No, but let us see what the Supreme Court has said. In 1991, supplementary one SCC. Para. Yes.
We are the shareholders to immediately we provide shares for right to buy having those services. Right now. Valuation. Was fine and this type of form is that not
The application was filed with respect to dwelling house and the shops and weekend land. But now your claim to purchase is limited to the dwelling house. Two-thirds of
the party seeks options here include third party that shareholder section 2 shareholders.
photograph of the house. Building house and land, you know what was that? For lordship and photograph. That 60 years they can have one day. Your lordship and photograph.
What is the difference between 2 and 3?
Strangers in the purchase around there. There is no strangers in this. Very good.
Yes.
Is the scheme of sections 2 and section 3 apparently is the property is such or the number of shareholders is many or if there is any other division of property reasonably can any other shareholder shares of the party. In such a situation, it has been obligated that the court shall order. And by
What we see now, the legal position appears to be when court comes to a conclusion that property is to be sold because it cannot be divided. Any shareholder can make a request to purchase the other person's share. And Supreme Court has held valuation is as on the date the right is exercised under Section 3 to purchase the other share. So that right is exercised on the date application is made to purchase. That is on what is the date? 5/6. So that is the date valuation must be taken.
Because certified by that application rejected matter. And this Honorable Court has.
Yeah.
Area number 35 on that executive order on that challenge. That order, they are filing best application.
There is copy of
Area number 35. That executive order is.
your application for the first time was made in IA-35, is it? Hmm? What happened to IA-23 and 24? What happened to those applications? Just one. Just one. Now, after this IA-23 and 24 was set as order was set aside in WP 1747, isn't it? You have a copy of IA-23 and 24. Just wait.
That IA number 23, 24 clause number. Therefore, they have made this application.
No, but his original application to purchase your share is saying that you to follow the direction. But how can you take that into account? The first time when you find must be that has not been the court has not rejected it. Court has only directed dispose of the right in terms of the order passed in the.
But they have not continued the IA number 23 and they have made this application.
But how can that take away the right in the exercise? Now, in so far as IA-23 and 24, only in so far as the dwelling house.
Purchase two-third share of.
But why did you file IA-35?
Because of the fact that the was set aside.
So, this application.
These are as far as the law is concerned, the date of making the section 3 application. Of that, it's the right question of exploring IA-23 or 24. What is that is because the market option is now 11.
Any order is on IA number 35 IA number 23, 24 that not Die number 23-24 was closed and gone. Now make fresh application. The order was gone and I am.
Okay, that we'll see. Now, I mean, that apart, legality is apart. What is the, let us see if the valuation is little more, then you pay little more and close the loan. Right? What is it? What is the current valuation according? What is the current valuation according to? What is the valuation?
So it comes to 7,128 for square feet. So far as the dwelling house is concerned, the total extent is can we see in that dwelling house is 75 per square meter. Total for dwelling house is concerned, it is 75 square feet. So it is 1 square feet is 7,128. So it is comes to 73,000. So one share 89 lakh. One share.
But if we were to hold the IA 23, no, correct. Now you sit and settle the matter along with this. No, legality is apart. No, that we'll see. Why did you file IA 35? You need not have filed IA 35. You could have insisted on reconsideration of the earlier matter and right of the order. Let us see. Legality is apart. Anyhow, all of you are co-sharers. Try to settle the matter. Settle it. Otherwise, I'll pass an order. If I were to pass an order, you will be at the losing it. I'm warning you now. The order. No, that is not possible. I'll tell you one thing. How you settle the matter, if you don't, and if I were to hold the 2012 valuation, then he will walk away and you will be left with that. You increase your valuation. Legality is apart. Legality is apart. I'm not on the legalities. I'm not on the legalities. No, now you increase your valuation and you settle the matter. That's okay. You want to purchase his shares, isn't it? And you are saying he has no right to, because he has not exercised his right to purchase. You are the only person, just wait. You are the only person who have exercised right to purchase. So now the only point he is raising is valuation is less. No doubt you have pointed out the legality, saying which date valuation is to be. Anyhow, once you instruct your client, see if there can be any settlement. Then we'll see what is true. But if we were to hold otherwise, then your valuation will shoot up. Look at it. Look at it now. No, I'm not entering into this. No, I'm not entering it. You see and see if there can be any settlement. You increase marginally at least your price. Otherwise, I'll pass some order. Just the matter week after next. Both parties are directed to explore amicable resolution regarding the valuation.
They have not come forward. They have not come forward.
You must go because you are. Let us see. Once you try, once your legality is apart, you sit across and try, and then we'll go on the merits. Interim order earlier granted is extended till the next. Yes. You want for mediation and referee here. What do you say? You want mediation or both of you only will? That's okay. That's okay. Now you are going to purchase their share. Just some give and take and close them up. Better no done. You both sit and instruct your clients. Yes.
Appear for the petitioner in this matter.
Yes.
I appear for the petitioner in this matter, Lordships.
Yes.
This matter, Lordships, are challenged. In this matter, Lordships, are challenged the order which has been passed by the trial court on 29/9/2021, my Lordships. In this matter, the petitioners had filed a suit for partition, and the suit has been decreed, my Lordships. After the decree, the petitioner filed an FDP proceedings before the trial court to get his share, my Lordships. In the FDP proceedings, the commissioner was appointed to demarcate the properties allotted to the petitioner. And the FDP order has also been passed on 1/2/2020, my Lordships. In that, the commissioner report has been marked as Exhibit C1. When the commissioner has drawn the sketch Exhibit C1, number by mistake has been mentioned as 6/2 instead of 2/6. My property is 2/6. In the entire decree in the FDP proceedings, the schedule, the property number is mentioned as 2/6, my Lordships. But in the sketch produced by the commissioner, it has been mentioned as 6/2, my Lordships. Hence, I sought for correction of that sketch, because until and unless that sketch is corrected in the FDP proceedings, my Lordships, in the order, it has been mentioned that the sketch is a part of the decree.
Yes.
So at page number, I will read the operative portion of the FDP proceedings, my Lordships. It is at page number 53. Order. The petition, one filed by the petitioner under section 54 of CPC for drawing final decree in terms of the preliminary decree of OS number 2530 of 2004 in respect of the suit scheduled properties hereby allowed, and the suit property be divided by meets and bounds in terms of the said preliminary decree of OS number 2530 of 2004, and also in terms of the court commissioner report cum sketch at Exhibit P1. The respondents are hereby directed to put the petitioner in possession of 1/3 portion of the suit scheduled property as per the terms of the court commissioner report cum sketch at Exhibit C1. Draw a final decree accordingly, and the court commissioner report cum sketch of Exhibit C1 shall be a part and parcel of the same. The next is a sketch, my Lordships, which is at page number 56. There in my decree also, my Lordships, the property number is 2/6 itself. At page number, in the decree, my Lordships, at page number 46, the property number is mentioned as 2/6 itself, my Lordships. In the schedule 46, my Lordships. All the peaks and parts. In the schedule, it is mentioned, my Lordships, it is mentioned the property bearing premises number 2/6, old number 9. So
Yes.
in the final decree proceedings also, the same number was mentioned by us. Only there is a mistake in the commissioner report, that is a sketch which he has produced as Exhibit C1. It has been mentioned as 6/2, my Lordships. Instead of writing as 2/6, he has mentioned as 6/2.
Now you read the impugned order. Now you read the impugned order.
Yes, my Lordship. Impugned order is at page number 63. I'll read ಆದೇಶ. ಅರ್ಜಿದಾರರು ಮಾನ್ಯ ನ್ಯಾಯಾಲಯಕ್ಕೆ ದಿವಾಣಿ ಪ್ರಕ್ರಿಯೆ ಸಂಹಿತೆ ಕಲಂ 151 ಅಡಿಯಲ್ಲಿ ಅರ್ಜಿ ಪ್ರಮಾಣ ಪತ್ರವನ್ನು ಸಲ್ಲಿಸಿ ದಾವಾ ಆಸ್ತಿ ನಂಬರ್ ದೊಡ್ಡಮಳ್ಳಿವಳ್ಳಿ ಗ್ರಾಮ ಮಟನ್ ಸ್ಟಾಲ್ ರಸ್ತೆ ಹಳೆ ನಂಬರ್ 9 ಹೊಸ ನಂಬರ್ 2/6 ಇದ್ದು ಆಯುಕ್ತರು ಕೊಟ್ಟಿರುವಂತಹ ನಕ್ಷೆಯಲ್ಲಿ 6/2 ಎಂದು ತಪ್ಪಾಗಿ ನಮೂದಾಗಿದ್ದು ಅದನ್ನು ಸರಿಪಡಿಸಬೇಕೆಂದು ವಿನಂತಿಸಿಕೊಂಡಿರುತ್ತಾರೆ. ಅಂತಿಮ ಡಿಗ್ರಿ ಪರಿಶೀಲಿಸಲಾಗಿ ಆಸ್ತಿ ನಂಬರ್ 2/6 ಎಂದು ಬರೆಯಲಾಗಿರುತ್ತದೆ. ಅರ್ಜಿದಾರರು ತಮ್ಮ ಅರ್ಜಿಯಲ್ಲಿ ಡಿಗ್ರಿ ಸ್ವತ್ತಿನ ನಂಬರ್ ತಪ್ಪಾಗಿದೆ ಎಂದು ಬರೆದಿರುವುದಿಲ್ಲ. ಆದ್ದರಿಂದ ಆಯುಕ್ತರು ಕೊಟ್ಟಂತ ನಕ್ಷೆಯಲ್ಲಿ ಸ್ವತ್ತಿನ ನಂಬರ್ 2/6 ಎಂದು ಬರೆಯದೆ 6/2 ಎಂದು ತಪ್ಪಾಗಿ ನಮೂದಾಗಿದ್ದು ಸದರಿ ಆಯುಕ್ತರು ಕೊಟ್ಟಂತ ನಕ್ಷೆಯಲ್ಲಿ ತಪ್ಪಾಗಿ ನಮೂದಾಗಿರುವ ನಂಬರ್ ಅನ್ನು ನ್ಯಾಯಾಲಯವು ತಿದ್ದುಪಡಿ ಮಾಡಲು ಬರಲಾರದು. ಆದ್ದರಿಂದ ಸದರಿ ಅರ್ಜಿದಾರರು ಸಲ್ಲಿಸಿದ
Yes, now what is your sought for stay of the FDP till this is decided?
No, my lord, FDP has been disposed of, my lordships. I have not sought for stay. FDP has been disposed of. After the FDP has been disposed of, I filed an application to get my name registered as per the DP.
Yes, you take out notice.
Much obliged, my lordships.
Emergent
Because
notice.
before the trial court also the respondents did not appear, my lordships, in the FDP proceedings. They filed wakalat and they did not contest the matter.
Yes, you take out emergent notice.
Yes, much obliged, my lordships.
Opinion application filed under order. The letter was quoted for argument. That should be just like it. Defendant must for permanent injunction against the defendant. Both parties have let in oral and documentary evidence. That was posted for argument. At that stage, my lord, defendant files an application. Section, my lord, was evidence that it is conducting on CBC or referring to not exhibit P1 document and exhibit D41 document forensic the trial judge not as per annexure E not in page 51. The relevant portion is in page 54. Page 54, Gerard well. In the present case on hand, both the plaintiff and defendants have lent their evidence. The case is set down for argument. I have carefully gone through the evidence for the record. In the cross-examination of PW1, the learned counsel of the defendant that Nishanaki Agatandaravel was he from the question of comparison of you do not bear the signature of the further it is pertinent to note that it is for evasion simplicity. The plaintiff must establish a possession over the property as on the date of the part. As parties have not admitted the signature of either of the documents exhibit D41 and D41, and there is no question of sending these exhibit for comparison and
So, what are these documents? P41. What is P41? What is D41?
One more application. This is the order. One more application has been filed as per annexure as to the not equal to Partition of the Act.
Page?
Right.
This is
This is a document where they are claiming a title. It says
this document is executed by
to have been executed by Sitaram Singh. He has written this document.
Who is this Sitaram Sundar?
He is the owner of the property bearing survey number 185.
And
Survey
here,
number 185, measuring 2 acres, 6 feet.
and the suit schedule is
Yes, but they are now taking meetings, especially to the extent of 50.
now Sitaram Sundar is the
Literally into 56 feet.
Sitaram Sundar is the vendor of the plaintiff,
No, he is a vendor, my vendor.
vendor of the defendant.
Yes, who has sold the entire agricultural land of measuring to an extent of 2 acres, 6 feet.
We are claiming portion of the property.
They are claiming
Rejection of clear application. One more application.
Okay, I'll come to you.
One more application has been filed. And that application is the connection rights. Page 67. Application filed under 45 and 47 of the Evidence Act. Federal Order 2210 of the by giving same reasoning, you does not try the not have rejected the
Read the reasoning.
there are
9.
There are 9. The second contention of defendant to that exhibit 41 was not executed by Mr. Plaintiff has denied the payment. Exhibit P41, P28, P29, 12. P29 is not accepted. Sir, I would like to read to when the court has to form an opinion on a point of foreign law or crime or as to identity of handwriting or finger impression, the opinion on that point of foreign law, crime, or the identity of handwriting or finger impression. Here that the court
No, so now I just want to know what is this? Correct. I want to know why this exhibit, what is the importance of P41? Just read P41. What is the importance?
No matter when the matter is closed, it has been rejected. One more application has been filed, that is also an extra rights came to be rejected. One more application has been filed under Article Rule 78. Now that application has been allowed not as not an extra in page 8.
In page
8.
Read that reasoning.
The plaintiff has filed this application for recalling and reading. Yeah. I said, what is the application in that uniqueness of disregard, I am of the opinion that the party can render any number of for making the evidentiary value of the document be considered at the time of the judgment. No doubt the defendant obtained expert report without the leave of the court, but this is not a ground to reject the application. The evidentiary value of the report of the expert be appreciated at the time of judgment. Taking into consideration however, I am of the opinion that delay in making the defense application is compensated to the plaintiff. If the application is allowed, the plaintiff will get an opportunity to test the recipe of the expert opinion. I find this not what has already injected the application.
Correct. Now that the value of that report, who is a commissioner at his instance, is a matter for appreciation. Look, there's a difference between the court referring. Now, suppose the court is referring it. That means the court has applied its mind and feels that the matter requires the opinion of a handwriting expert. Now, suppose the court has rejected it. Correct. No, just the court has rejected it. No doubt about it. So the court is of the opinion that it is not necessary. However, if one of the parties gets a private report, value of which is to be treated as evidence of that party and not that of the court. Now, suppose a commissioner report is not objected to by the other side. It becomes a part of the court record, and court puts almost its seal of approval on it if it is not objected. Here is a case where at his instance he got a private report. Evidentiary value automatically is as if he has produced some document.
There is a report or by appointing the commissioner, he files two applications. Both applications have been
So the court doesn't want it. However,
in the beginning of the admission, what has happened? Due to the confusion that will not the application is quite that you know. There are 11 page 6. Page 6, there are 11. The respondent filed the application under order 17, referring to section 151 CPC. 11 hours of the court to make order for the additional entity or given the evidence of the basic purpose of or is to enable the court clarify any position and it would may either room or under interest of any party. Recall any witness at any stage in that regard. This power can be exercised at any stage of the court. No doubt one thing what recall already led by it can also by the parties is very no matter what for argument. Section 45. What has given a categorically finding that do not include there is no necessity to appoint an expert. Indirectly, we are not know over not to over. This application is quite under of PPP. So, he obtains a report from a private. What that not
read para 15. 15.
50.
1-5.
Section 151 is the substantive provision which creates concept any government merely recognize the discretionary power inherent in every court. According to law, to do what is the right and do what is wrong. But the information is given of it. As the provisions of the are not accepted. Section 1 that the court does not accept or imply to cover any particular law. The inherent power can be used. What contains or dealing with particular topic or aspect or mind is or element or not being of or to connect or in a manner in other words, the court cannot make legal provisions for section 1 or there is a remedy or procedure is provided. The inherent power or complementary to the court is typically does what to that court is free to exercise them for the mentioned in section 151. So the memory is not covered by any provision of the one in conflict with what has been expressly provided in the words or be against the intention of the legislature. By exercising the inherent power, the court is applying water as there is no legislative guidance, deal with the procedural situation and exercise of power depends upon the legislation and wisdom of the court. And in the fact and circumstances, yes, the excess of any
Okay, let us see just what do you say? Which are
by Sitaram's 5 children in the year 2006. But this fact is not disputed in today's
no, what is this annexure A?
It's a mutual
Read it.
But the type of the election so, yeah. Okay, why?
Now this is executed in favor of plaintiffs.
Mother.
Yes.
How they the grammar survey number first 186. Actually, mark this. This is the property where the defendant the property which has been executed was handed over this case, the number 86, mentioned to the extent of the
Where is the measurement?
Below that column.
East to west.
Yes, Lord. Krishna, 2022 means 186. Only description is not in respect of server number 186.
What is the plain schedule?
Getting what server number 185.
But this is 185.
They are making a claim. So only Maharaj, this the time of filing this suit, Maharaj, this document was not available. After the application for 39-102 was allowed, I had challenged the same before the court, where the upper court has rejected. Because that Maharaj, they have amended the creating this document. Where now during the course of evidence, I came to know that Maharaj, savings, original savings, which have been executed by Sitaram in his own handwriting, was sought to be referred to the FSL. So there was a mistake in the filing the application, but when mentioning the correct document number, that is instead of exhibit D 29 and 29, 28 and 29, I mentioned it D 41.
No, just find out that in their plaint,
Yes, ma'am.
they rely on this document.
Yes, ma'am.
Point out.
Yes, ma'am. Plain was submitted. I'm saying I'm not. Can you refer to
Page?
paragraph? This was not incorporated into the at the time of granting temporary injunction. The plaintiff submits the social property belongs to Sitaram.
Correct. 2C.
Yes, ma'am. A.
2C.
Development. 2C.
Just read.
Yes, sir. The plaintiff submits
So this is the document which, according to you, they're relying on. Now, what is the purpose of referring that P41?
defendant has disputed the signature and the handwriting of Sitaram Sundram because under exhibit D28 and D29, which have sought for referring the document for FSL, was duly executed by Sitaram Sundram as he was a tea trader and a sharper of that village. And he has sold his property in favor of the very defendant. I mean, those original
So your contention is this exhibit
P41 where
P41
yes, sir.
is a concocted document,
Yes, sir.
and since they're relying on that document, if that is disproved, then his case will collapse.
Yes, sir.
That is your contention.
Yes, sir. Because Maharaj, I have sought for experts looking in the retail handwriting expert in the government.
Just now, you have also challenged your order.
Yes, sir.
Why? We have 515, both the orders. Now I'll just put it to you, just think about it. There's one way of looking at it. I mean, legality is apart. Now, if it is his contention that this exhibit P41 which you are relying is by virtue of which you trace your title to 185. Now, if assuming that is referred to the forensic lab, let's say government forensic lab, that will end all the issue. Now, I'm just asking. Now, let's not go into the present IA for recall, wherein he's seeking to rely upon some private thing, because that may prejudice the court, and you may find it a little difficult to convince otherwise. Now, if by consent that is referred, though there may be some delay, that may bring out the truth either way. It may either support you in the event of which it will strengthen your case. If it is not, then that would not have its evidentiary value. Why can't?
For their objection. Further is on me to prove my case. Give your suggestion, my lord. Times, picture E and annexure. Are those applications have been rejected twice. There is suggestion.
That evidence he was pointing out is not a settled admission, and there's some ambiguity is what is.
Burden is on me, my case. And the matter is posted for argument. Without me, let you know.
No, but look, that is no correct. That is your document. Suppose the document is disproved, then there is some difficulty. So if
burden is on me to prove my case. If I prove my case, not then I will succeed. Otherwise, my student will go.
But if he proves that document is concocted, then your case will. So why not let it go? Let a report come.
For argument. And then the twice if those applications are rejected. One more application will not continue. Having regard to all the stress and exercise, that will not be. Section on. I got the other one that
Where are you reading? CP 41. Objection for comparison. Yes, read further. Where is that admission they say?
Before the plans. Page 11.
Yes.
Paragraph 2. I think the which starts out here, while cross examination, signature.
No, this is the cross examination of
PW1.
PW1. No, this P41, according to him, is executed by Sitaram Sundaram.
No, we are not executed.
According to them.
According to them, we have been executed by Sitaram.
Now, what is the admission that the court? No, but this is the admission of the plaintiff. No, that suggestion will not have the effect of taking away. How can suggestion have the effect of taking away? No, that may be so, but I was under the impression that defendant is admitted. No, that by itself does not amount. I can go to the forensic. The second IA I'll allow. Let it not be that let it go, let it come. It will either support you or support you. That is
That event, let it be referred, what reference is that some may happen. Therefore, it may be referred to not outside government.
Hyderabad. Yes. So the second IA, I'll allow the second IA. Which is that second IA? Which writ petition? 5-1? A number? Page? This is the second IA. Order? The WP 515 of 23 has been filed by the defendant number 2 calling in question correctness of the order passed on IA 23 and 25 MOS 202 of 2011, whereby applications filed to refer Exhibit P41 along with Exhibit D28 and D29 to compare the signature of Sitaram Sundaram has been rejected. The bracket IA 23 and which is the other IA? No, the one previous to this. Previous to this. And whereby both are 23. This, now the IA of P41 with 28, 29.
That is 25.
With 25. Huh? And petitioner also called in question validity of the order passed on IA 23, whereby the court has rejected the application to refer Exhibit P41 along with Exhibit D41 to the Forensic Laboratory, Science Laboratory, Bangalore, for comparing the signature and handwriting found on the said document. Next. In the meanwhile, the defendant number 2 had also filed application under order 18, rule 17. That is it. In the other writ, that is 24758. That page.
Section L. Page 18.
Page
18.
in the video. Order 18, rule 17. Seeking for recalling the stage of further evidence, recalling the stage of evidence of the defendant, and a sought for recalling of DW1 to produce and mark documents including report of a private handwriting expert. The trial court has allowed said application by its order dated 28th November 2022, and the same has been challenged by the plaintiff in WP 24758 of 2022. And in light of the similarity in the controversy, it is deemed appropriate that both the writ petitions, that is WP 24758 and WP 515 of 23, are to be disposed of together by a common order. The facts, the narration of facts are limited to disposal of the present writ petitions are as follows. The defendant number 2 had initially filed application IA number 20, IA number 23 under 45 of the Evidence Act, seeking for reference of Exhibit P41 along with D41 to the FSL, Government of Karnataka, Madiwala, for comparing signature and handwriting found on the above stated documents. The said application IA 23 came to be rejected by the trial court. Where is that order? In the trial court had observed that the application was filed in the stage of arguments, and in the cross-examination of PW1, counsel for the defendant had put a suggestion in Kannada. CP 41ರಲ್ಲಿರುವ ಸಹಿ ಸೀತಾರಾಮ್ ಸುಂದರಂ ರವರದೇ ಎಂದರೆ ನಿಜ. Close inverted comma. Accordingly, trial court was of the view question of comparison of Exhibit P41 with D41 did not arise. Next. However, the second defendant at the time of arguments has fairly conceded that the question of comparison of P41 was by mistake mentioned along with the signatures on exhibit D41, and accordingly fresh application came to be filed as IA 25. The IA 25 came to be filed seeking for reference of exhibit P41 along with exhibit D28 and D29 to compare the signature of Ram Sundaram, and accordingly reference to was sought to be made to the FSL. The said application was filed for comparison of the signature as well as handwriting. The said application, however, came to be rejected as per the order came to be rejected as per the order of 28 November 2022, wherein the court has adopted the identical reasoning as was found while disposing of IA 23. Meanwhile, subsequent to such a rejection of application in IA 25, the defendant number 2 had filed an application under order 18 rule 17 seeking for, so that in WP 24758 that IA is at page
56.
under order 18 rule 17 and to produce and mark the FSL report. The defendant sought to produce the report of a private handwriting expert, isn't it? And opinion of such expert dated 12/9/2021 as regards to the disputed signature on exhibit E41. Said application has been allowed, which has been challenged by the petitioner WP 24758 of 2022. That insofar as the government's in the plaint after amendment is to the effect that Sitaram Sundaram had, by virtue of exhibit P41, conferred rights to the plaintiff with respect to survey number 185, though as per exhibit P41, it was wrongly mentioned as survey number 186. Clearly, the premise on which the plaintiff is claiming injunction is on the basis of the government in the amended plaint at page para. Where do you get the plaint? Of which writ? In terms of the government at para 2A and 2C, No doubt, if it is the plaintiff's case,
To be also.
2A, 2B, and 2C. No doubt, if it is the plaintiff's case, that exhibit P41 is a document on which the plaintiff seeks to rely, and it is the defense by the defendant that the signature of Sitaram Sundaram found on exhibit P41 is not that of Sitaram Sundaram. Said aspect will have a bearing on the trial. The mere suggestion stated to have been put in cross-examination of PW1 that exhibit P41 as the signature of Sitaram Sundaram will not have the effect of taking away the defense or watering down the contention relating to the doubt of signature of Sitaram Sundaram on exhibit P41. Taking note that the application under Order 18 Rule 17 has been allowed, whereby the opinion of a private handwriting expert is sought to be placed on record. It would be appropriate and serve the ends of justice if, in fact, IA number 2025 itself is allowed and the opinion of a handwriting expert is placed before the court. It is to be noticed that exhibit P41 is indeed an important document insofar as plaintiff claims traces title to the said document, and accordingly, it would also be an important part of the defense of the defendant if the veracity of the signature and handwriting as sought for in exhibit P41 is subjected to the report of a handwriting. Accordingly, I find that the reasoning adopted by the trial court in rejecting IA 25 is erroneous, and the mere suggestion put forward in cross-examination of PW1 by the defendant is not sufficient to take away his right to protest regarding the signature of Sitaram Sundaram on exhibit P41. Accordingly, IA 25 is allowed parties to give their memo of instruction. In light of allowing of IA 25, the no orders.
Okay, allowing the application that ought to be negative.
So in light of allowing of IA 25, IA under Order 18 Rule 17 by the order as per disposed of as per the order on IA number.
No.
No, correct. That as per order dated 28/11/2022 may not be required to be permitted to come on record in light of the order passed on IA 25, and accordingly, ensuing order is set aside in light of IA 25 being allowed and the quality of evidence of IA 25, which would come out after report by the expert is placed on record, would be sufficient and would take care of the interest sought to be propounded by producing the document under Order 18, Rule 17. Accordingly, the order dated 28/11/22 is set aside. In light of allowing of IA 25, question of passing order on IA 23 would not arise. Accordingly, writ petitions are disposed of. IA 25 is allowed. However, the document to be referred along with memo of instructions to the Forensic Science Laboratory at Hyderabad. Accordingly, petitions are disposed. Yes, what is
Yes.
this?
The petition got a approach this normal code seeking for a mandamus not annexure G and C not annexure G.
Now you take me to a writ petition code first.
Read the copy.
Now who is the contesting party?
Contesting party is what 1 6. And yes, I within 2 minutes for the edit the fact and the process will start on the subsequent part in the second order. But the petitioners not approach.
Now you refer to the rank in the writ proceedings.
The petitioners not approach the Sample code seeking for implementation of annexure G page 69 again. Annexure G page 69.
Now you are the respondent or the
No, I am the petitioners.
in the writ petition. So you are
I approach not you all
annexure G.
annexure G page 69. Not this is an order passed against respondent number 6 under 321(3) of the Karnataka Act on the ground that 6th respondent not sector without the sanction plan.
You had sought for the
I sought for implementation of annexure G, which has reached finality. This order is dated not 25/6/2019. Not when the matter was listed not before your lordship plot, the BBMP plot now plot you kindly see the order passed by your lordship plot dated 27th November 19. That is on 27th November 2019. But the paragraph 5 may kindly see. Paragraph 5. But the learned counsel for the respondent PPMP has rightly submitted that unless the question of identity of the property is established, question of taking further action under 323 of the Act becomes untenable in the light of the request whereby is made at election ENI. But the council will not appear for the PPMP bill as sufficient fact regarding identity of the property, which is not plot raised by respondent number 6 hearing. Respondent number 6 plot who support this order, who has not challenged this order, never said that there is a disputed identity of the property. It is my case plot along with the review petition. I have produced plot annexure G page 22. Survey is not done during 2010 itself, which is very much within the knowledge of the BBMP. Can you see annexure G not page 22? Review petitions. Annexure G page 22.
but this read of the writ petition order. Read the writ petition order. Let us see what is it that
But your lordship not directed the authorities to resurvey based on the submission made by PPMP. My respective submission is annexure B page 22 along with review petition. Survey is already done during 2010. Annexure B for Bangalore page 22. This survey is done during 2010 itself. It is very much within the knowledge of the PPMP. If this survey sketch is brought to last probably your lordship should not have passed the order or a second survey. That is the only limited.
what is the identity now as per this sketch?
Sketch plot is very clear that in the 19 plot 92 part 5, plot number 6 has the illegal structure without sanction plan. Plot now plot
Just point out from the sketch.
Sketch plot kindly see plot 92 part 5. This is totally plot initially it was 92, subsequently plot it is numbered and 92 part 5 is where plot illegal structure is up according to my submission. 92 part 5 plot.
Yes.
92 part 5.
Yes.
My immediate submission is plot if this survey sketch is brought to your lordship's notice plot, probably your lordship would not have directed second survey. One, even though the sixth respondent suffered the order in 2019, not the BBMP for the best reasons plot are not implementing the state order. One of the protects. Now the BBMP itself says that there is a dispute regarding identity property, which is not raised by sixth respondent. The BBMP says it is a duty of the BBMP to implement the order passed by them under 323. My submission is not in the guise of this dispute. The council says that there is a dispute. Who says we don't know? Who says that there is a dispute regarding identity property? My submission is unless the order passed by 323 of the BB Act side, EPP is going to comply the orders. Now, under the guise of second day, survey, they can't go on postponing. Which is not, even though 2019, till today, success not done, state order.
As per Annexure B,
Yes.
as per Annexure B,
Yes. Not, my second argument is, if the BB says that Annexure B will have produced a service case was given by me, if it is not available with them, I will give one more copy to them. Let them consider this sketch and pass appropriate orders.
so who appears for BBMP? You appear for BBMP. What do you say? Yes. Now, who appears for the landowner? The private. Now, what is statement of objection? What was the defense that was taken by you? In the in the earlier round of litigation, the fight. Page. Correct. Yes, sir. 15/7/2019. Letter dated 15/7. No, but now they're saying it's already identified as per this, and it shall be to the review petition. And it shall be to the review petition. Oh, correct, but the next R9, rightly or wrongly, they referred it to the revenue office. If it is not here,
One second, right?
that is there now. Pass any order must be in the presence of the other property owner. No representation on behalf of R6. Relist the matter next week. But in light of R9, in review whether we can pass any orders.
Survey which is not already done, then is not a lawsuit. Probably what your lawsuit is not done for second, not.
Let us.
Each respond never says, it never disputes. GBL people, they say that.
But,
How can they say that?
but you also didn't produce that letter, that document in the writ petition.
Based on the plot,
Let us
lawsuit is not.
relist the matter on. Let's relist the matter on 17. You just inform counsel for R6 telephonically next time, so let him be. 17.
In the matter listed at serial number 25, my lord, I
Yes.
appear for petitioner.
Yes.
Now, the Legion says it is listed for non-compliance of office objection for the second time. It came up for the first time for non-compliance of office objections on the 14th of November 2022, my lord. As many as 6 office objections were raised, 2 of them substantial and the rest were minor.
Now let us see, now they've raised something. Nevertheless, I will take it up on the main. In case there is some urgency, you let me know what is the main matter itself.
I will briefly state the main matter, my lord, because I have not prepared fully to submit on the main matter. The main matter is this, lord.
No, otherwise, I'll have it. I'll have it tomorrow or day after tomorrow. Get ready with the main matter. We'll see what is to be.
I'll make my submissions if your lordship permits me.
If you're not,
Yes.
If you're not asking for any interim prayer, then I'll issue notice. Let us see.
I have asked for stay of the proceedings in the trial court. That is.
No, so get ready and come. I will have it day after tomorrow.
Very well, my lord. Obliged.
Relist the matter
on Monday. Very
well. Meanwhile, there's some 3 small objections. If you can attend to it.
I will, my
Office objections to be complied with in the interim. Yes.
Obliged.
Yes. In light of the explanation of counsel for the petitioner, office objection is overruled. That is only office objection, is it?
Yes, sir.
Yes, my lord. There was.
No. I'm in the next matter. Yes. Manjula. 26. ಇದು attend ಆಗಿದೆ. ಆಯ್ತು ಪಕ್ಕ. ಇದರಲ್ಲಿ ಏನ್ ಬರ್ಬೋದು? In light of the submission of counsel to the petitioner, office objection kept in abeyance. What is the main matter?
For the relief of filed by the respondent. During the course of trial, I marked two documents, my lord. That is Exhibit 31 and T31 and D30, page number 58 and 68, which got marked without there being any objection.
GPA.
Yes, ma'am.
Page 58 and
68.
yes.
Two GPS which went marked without any objection by the plaintiff, and subsequent to marking the document, based on this document, I was fully and effectively examined and was advanced for arguments, my lord. At that point of time, page number 76. Now, I beg your pardon, my lord. Both the documents are registered documents. Both the GPS are registered documents. Now, page number 76, plaintiff files a memo stating that furthermore, the said document is insufficiently stamped and else is not admissible. Now, to that memo, my lord, I filed my objections at page number 78. When, after hearing the parties, the trial court passed an order at page number 82, my lord, thereby rejecting the memo filed by the plaintiff, saying that since the document is duly registered and copy has been placed and no objection has been raised by the plaintiff respondent hearing at any point of time, and since the matter has been posted for arguments, contending so it has rejected the memo. Based on this memo, based on the order passed, the respondent hearing prepared a repetition notice on page number 85. Remanding the matter, page number 104, operative portion and read only the operative. Page number 104, 5 lines from the bottom, 5-6 lines. In this regard, the trial court has arrived at a conclusion that the payment of stamp duty by the executants is just and proper, and therefore the said documents are not required to be informed. Perusal of the impugned order makes it clear that same sans reasons, much less the provision contained under the Karnataka Stamp Act, has not been discussed. The trial court, without considering the relevant articles and schedule in the Karnataka Stamp Act, has arrived at a conclusion.
Then what happened?
Then it was remanded to rely upon the articles only. Now, the trial court, page number 15, has passed the impugned order, thereby expunging both the documents, which has already been marked, based on which documents cross-examination has also been conducted. That too relying upon page number 16. Hence, in view of the principle laid down by Honorable Apex Court reported in the AIR 2008 NC 166 in the case of Hariom Agarwal versus Prakash and Maravia, the documents marked on behalf of defendants at Exhibit T1 and D30 and D30 dated so and so is hereby expunged. Now, that judgment memo speaks about the document, the next copy of the document, which is not at all registered. May I pass that judgment?
Now, what is the stage of the suit?
Now it has been posted for argument. If without relying on this document, my lord, if by any other, because based on the GTA, I have formed layout and I have put 180%.
In light of the contentions raised and submission that matter is set out for arguments in the main suit, and that without reliance to the documents in exhibit D31 and D32, it is not practical for the defendant to advance arguments in the main petition. Subject to further consideration, there will be stay of proceeding in the trial court in the next day. So let us see
Take
the
notice.
let's see.
I have a copy. Yes.
The matter was posted for judgment. Comments stated in both sides.
Oh, no, not both the sides.
Posted for judgment on which side?
That plaintiff might have completed, respondent, defendants have not at all.
The stay of
I request a short date will be fixed.
there would be stay of proceeding before the trial court, and trial court is directed to defer passing of judgment in the next day. This is the matter week after next. Date for the week after next.
Okay.
Devendrappa, 27.
Unmute Madi.
I
Please,
appeal for the petitioners,
yes.
my lordships.
Yes.
In this matter, my lordships, I've challenged the order decree which has been passed by the Lok Adalat committee, my lordship, Virajpet, wherein the petitioner is not a party to the said decree, my lordships.
Yes.
But what has happened is the petitioner is related to the family of the respondents. The respondents, they are not the close relatives, but their initial is the same Kandera family. They belong to Kandera family, my lordships. What has happened is the respondents 1 to 4 filed a case suit for partition against the respondent number 5. That is Suresh Kandera, Kanderka Suresh. My name is Suresh Kandera, my lordships. The father name is also different. They have included my property, that is survey number 143/1, and have sought for a partition of the suit scheduled property, my lordships, which measures 2 acres 19 guntas. In Lok Adalat, kindly see annexure D, my lordships. Annexure D is the suit which they filed before the senior civil judge at Virajpet, wherein the respondents 1 to 4 filed a suit for partition against the 5th respondent, that is his name is Kanderka K. Suresh. They are not the close relatives, my lordships, but they belong to Kandera family. The name of the petitioner is Suresh Kandera, my lordships.
Now this property stands in your name. How do you show?
Yes, my lord. I have produced a document to that effect. The document annexure A I have produced, my lordships. That is a partition deed. I have inherited this said property from my father in a partition which has taken place in the year 1995, my lordships. I and my sisters, both my sisters have got the said property.
Now just show, correct. Just show from annexure A.
Yes, my lordships.
Where it is allotted, which is the relevant paragraph.
Page number 12 may kindly be seen. The chart is being mentioned.
Yes,
ಈ ರೀತಿ ಉಂಟು ಮಾಡಿದ ವಿಭಾಗ ಪತ್ರಕ್ಕೆ ಅಡಕವಾಗಿ ಆಸ್ತಿಯ ತಪಸೀಲು ಎ ಶೆಡ್ಯೂಲ್ ಆಸ್ತಿ 4ನೇ ಪಾಟಿದಾರರಾದ ಕಂಡೇರ್ಕಾ ಕೆ ಸುರೇಶ್ ಅವರ ಪಾಲಿಗೆ ಬಂದ ಆಸ್ತಿ.
Now this partition deed is prior to the compromise.
Yes, my lordship. The partition deed is in the year 1995, and at item number 4, 143/1 survey number 2 acre 19 guntas.
Yes. In light of the contention that the settlement has been entered into before the Lok Adalat with respect to survey number 143/1, which belongs to the petitioner herein, to whom property had fallen by way of partition, was not made a party before the Lok Adalat. There would be,
There is no necessity for them to make me as a party. It is my property. They have mentioned my property and taken partition, my lordships.
now what is the interim relief you are seeking?
Let them not file any for FDP proceedings, strict possession of the property, my lordships.
Subject to further consideration as it is illegal. There would be
Therefore,
stay
the further proceedings,
of
my lordships.
further proceedings in OS 38 of 2022.
13/8/2022 is a decree.
The award of the Lok Adalat is dated
13/8/2022, my lordships.
pursuant to the order of the Lok Adalat dated
13/8/2022.
13/8/22. Issue notice and
Much obliged.
objections to be complied with in the interregnum. Weeks time granted for necessary compliance. Also,
31.
no? Correct. I was of the view that if the communication is to be treated as a communication under Article 229(2), you would have to make the High Court as a party, and so that the High Court takes its stand as to the nature of communication. Now, suppose the author of the communication is the High Court. If the High Court were to say it's one under 229(2), there ends the matter. There's no question of interpreting it. If the High Court were to state it's a communication at 229(2), and that is to be made by the author, how can we interpret it in the absence of the author? This the,
Regard to the enhancement of the base.
no, correct. Whatever it is, who is to say that this amounts to a communication at 229(2)? It's for the High Court to say. So let them be made a party, let them take that stand. Once they hold, when the High Court says it's a communication at 229(2), nobody can question that. Then it's a matter of how is that 229(2) direction to be implemented. It's the matter week after next. That you take your stand. Yes. So correct, you'll have to file under order 1 rule 10, not under order 22. If the person has died earlier to the institution of the proceeding, how can you file? And the question of abatement will not arise. It already person has died prior to the proceedings. So you seek for impleading them. Now notice must go on that. The counsel for the petitioner. Who appears for those? Can we allow that application? Can we allow? IA 3 of? They submitted that the third respondent died on 9/9/2020. No, after the institution of the writ, Now 1712. No, no. Writ petition is filed on 1712. You verify, we'll have it next week. Relist the matter next week. Yes, check it out. Yes,
55.
please.
We have not prepared a plea in this letter, and we have invoked the writ jurisdiction. In the normal and regular circumstances, we also have invoked section 96 of CPC in appeal. And this is a matter arising out of partition. I am one of the daughters, and we're all 6 brothers and 3 daughters. At the time of filing this, my father was alive. And later on, it was decided that the matter is a ancestral property, and you are not entitled to the petition. That is what the court decided in way back in 2017. And relying on the judgment in 2016, it said that when the daughter is applying when the partner is not alive, this she cannot claim equal share. So later on, that was passed in 2017. Later on, what has happened? This was an 18 judgment came. In Naman judgment, it said no matter whatever, she is she entitled. The conflict was, the problem was prospective and retrospective. In that conundrum, we couldn't really take up the matter in the appeal. Then again in 2020, the full bench of the Supreme Court decided and conferred status of proportional status on daughter on before or after the amendment.
Correct, but
So therefore, the share.
now what we would feel is that you file a substantive appeal against that. We will say, we'll grant liberty to challenge it appropriately, and you take it up in a regular appeal, not in the writ proceedings.
It was my thinking was, when we go for an appeal, there should be some question of law, also question of fact in the first appeal. So here, as it is, we are not agreeing with what the court has decided about the fact that the ancestral property and you don't get share and you get only the share of your father, predeceased father. Out of that one share, you all daughters you divide. And my brothers, they get 11 share. So later on the 18th judgment removed that clause. Then again, that has been very much clearly clarified in the Supreme Court. So therefore, instead of coming into the appeal, I have approached this honorable court to give direction to reapprise and re-adjust and modify the shares. As per in light of the Supreme Court judgment 2020, also in light of the Supreme Court judgment 2018, which clearly said that even if the matter is not for FDP, it has to be recorrected, readjusted, and modified as per the Supreme Court judgment. That is only my humble.
So you're saying the preliminary decree may be modified. So the preliminary decree may be modified, taking note of the judgment of the apex court. That is the relief you're seeking.
To refer back the matter in the light of the Supreme judgment, it has to be done. 18 judgment and also 19 judgment. The judgment is passed in 2017.
It's only reworking of shares.
That's all. If the modification taken place, all the children of the deceased will get equal share.
Which is that judgment you said, even where matters pending in execution?
Matters pending in FDP.
What is the judgment of the? You said there's a judgment.
Judgment actually. It is at the main order is at page 54. 54. What?
No, you said there is a judgment which says even if the matter is pending in execution, this change in law can be taken and there could be adjustment.
Yes. Judgment I have placed here at Annexure D. It is Dhanamma.
No, where is the observation stating even in pending execution?
Order is in the petition.
Yes, para 27. Para 27.
I read it.
So yes, you take out notice. Pointed out by
And one
learned counsel. No, you take out notices. then pointed out by counsel for the petitioner that there could be a readjustment of the shares in the preliminary decree in light of the change in law, which accordingly issue notice to the respondents.
At least the
Let us see, let us see.
Maybe my brothers have got rushing, and that may kindly be stayed, and notices may kindly be.
We stay of the FDP proceedings till the next date. Issue notice, same order. Yes. The question of maintainability is kept open to be considered later stage in light of the submission that in light of the judgment of the apex court, there could be readjustment of the shares as declared in the preliminary decree, taking note of the subsequent change in law. Yes.
Lord, I appeal for response.
Yes.
Lord, I
Yes.
Be the state of that particular order. Let's-
Where is that order?
By way of,
Just read that relevant portion.
page number 18.
Just one, just. Yeah.
And by the memo,
Paragraph? Yes. Yes. Yes.
If you want to take it, that is stated that review of the ex parte interim plan. Because things like not proceedings. But I want to practice that.
Today, not everyone. Passing only have the cover of silence. You have an option either to hide body or to place it in the cover of silence. And most of them today, every letter. The deputy commissioner.
Now that insofar as the symmetry is concerned,
Yes,
the trust manages or what?
the trust manages under the challenge of the deputy commissioner. Because this is a land.
Where do you get that reference? Where do you get this position which you're saying that the symmetry is managed by the trust?
I place that. I place for the ground. I here only. It's the law. Oh,
It's what you say now, they are a necessary party. Yes. So that's the order dated. Then now,
Page 10 of the same compilation notes which they referred to, the memo which they filed.
no, how do you say they're not necessary party?
I have filed a super injunction.
Correct.
It's a super bare injunction.
Ah,
But the bare injunction is not in respect of the entire graveyard what they are claiming. But
No.
I am only seeking for an injunction in respect of 2 or 3 houses which are situated adjacent to the graveyard.
that is-
Apart from that, you lords may kindly appreciate what is passed in the requisition order. Please tell your lords.
it's the password. After the division bench means. But how can you object to them being a party when at their instance there's a direction?
I am not
to
seeking
remove
for
it?
any relief against them.
No, that may be
I am
different.
the
That may be
dominant-
different. That may be different. But to state that they can't participate in the proceedings is to stretching it too far.
I'm not seeking any relief against them.
That may be so. That
I
is-
will submit.
If you want, you can file. There's no bar. You file. Now, after there's some division bench. Otherwise, we'll repeat it tomorrow or day after.
Tomorrow I have some proceeding. Otherwise Monday. Tomorrow I am not in town.
Let us see. If it doesn't reach, then Monday.
Today I am fine.
If it doesn't
Otherwise,
reach, then Monday.
Obliged.
Huh? Let us see. Let us see. You ask dates with him. Let us see what happens to the division bench. If it collapses, we'll reach.
ಶಿವರಾತ್ರಿ ಹಬ್ಬಕ್ಕೆ ಬೇಕಾ ಅವಳು ಒಂದೂವರೆಗೆ ಫಸ್ಟ್ ಮಗನ
ಪಕ್ಷ ಅಪ್ಪೆ ಬಂದಪ್ಪೆ ಹತ್ರ ಇದ್ದೀನಿ ಅವನಪ್ಪ ಹತ್ರ ಇದ್ದೀನಿ ಬಂದು ನೀವು ಊಟ ಗಿಟ ಮಾಡ್ಕೊಂಬರಲ್ಲ ಅಲ್ಲ ನೀನು ಸರಿ ಸರ್ ಬಂದಪ್ಪ ಅವನಪ್ಪ ಹಾ Ella come on record for July 20. That of the day.
Point number 3 expired. Who are the legal representatives? Number 3.
They have the daughters.
Already made. That's the notice on the. The file occurrence. That to file occurrence, then only we can allow.
I
So
don't
find it by now.
sorry, the husband who is also a respondent number 4. And
Karatnama would have. Tomorrow they refuse to give him a Karatnama in your office. Anything will record, you will file it. Will allow it. Immediate file it. During the pendency of the above matter, point number 3 expired. I 2 of 2022 has been legal. J. Kashyap Naik. Such notice, CA2 of 2022. It seems to and is granted a week time. File is within submission. That in principle, we have no objection. For the said application, we are now also taking it. Then do and you get amended first cycle next time. You carry out the amendment that this bench will have to be constituted only for this. For this technical aspect, if we set and it gets adjourned, you get the amended cost cycle, carry out the amendment, and we take up your review petition and dispose of that. Here only, we'll take it here only.
one of them is more is R14. Whereas most legal layers are already on it. So I would like
to explain. For the legal representative R14.
14 to 15.
They can then by Krishna. Then by Krishna, the counsel acting person hearing a petitioner submit that respond number 14 has also expired. And respond number 15 to 17 are this legal representative. We are already on this. For 15 to 17. 6 for a week time. Verify and make it. Anybody else is expired?
No matter, yes, my lord, but they are submitted. For example, respondent number 2 was deleted by the lower court on 26/8/2020. Heirs of deceased number 2 respondent are 1 and 3. And 3 has now expired. So that's this.
R2 who appears for R2? You appear for 1 and 3. 1 and 3 can be treated. Memo has been filed by the party in person, stating that the respond number 2 will expired and respond number 1 and 3 are his legal representative. The Kashyap and Naik, who appears for respond number 1 and 3, concurs with the said submission. Respond number 1 and 3 are treated as a legal representative. R5, 6 to 13 are the legal representatives. That's also fine. Similarly, R5 is also C. And R6 to 13, take it to the then R6 to 13 are treated as legal representatives on number 5.
And finally, heirs of respondent number 18
18 also is passed away. 18A and 18B are both.
Oh, come on then. That has been allowed, that application has been allowed. So no other pending technical issues are not pending. You have. RFA may be pending, but RP is what we are concerned. Now in this RP, what we are thinking is a RFA. Anyway, it is listed. There is no point in keeping this matter pending. Subject to any alienation, if at all, will be subject to the. Then you go ahead and get the RFA this one. This bench cannot hear. They're only concerned with the RP. We'll pass that order next time. Any alienation will be subject to the result of this RFA. So we'll observe that, dispose of your RP, and direct the RFA to be placed before the concerned gossip bench. So that you can argue the matter there and finish it.
Again, what you decided, the RP, in fact, stay place in relation, new rules, new properties.
From last 4 years, there is no order which is made. Now, reviewing that order and putting it back in place, create order. We'll observe that any sale from the time of filing of the RFA or from the time of filing of the suit is subject to the result. If you succeed, that will be satisfied. You will have to succeed in doing that. For that, you will have to get the RFA argued. You argue the RFA and go ahead with the matter because that is been pending from 2006.
The RP in relation to RFA, that will be part of my argument.
RFA would be completely different. We are only concerned with that review of one order. That is why this bench is being specially constituted. Once we finish RP, we become counter-subject. We go before the last. By next Friday, you'll do the next week.
What is the date?
2017. 117 or 20?
17th.
So will you be able to file your wakalatnama, carry out this amendment and everything by then?
I'll be able to.
Do one thing. Finish it by 17th. We'll have it on 24th. Then file your wakalatnama in the registry. File your.
I have it ready. In fact, I will have it ready tomorrow. So
File your wakalatnama. Again, it will get adjourned unnecessarily if they are not filing wakalatnama. Have it on 24th. By that time, you finish whatever you are required. You'll file your. Previous one, 24th at 2:30. Get your wakalatnama and file it. No more agenda.
List on Monday. Still notice is not. Huh. But that by itself will not be sufficient. We'll have it next week. We'll ask the office to put up the postal track. For what? What stage? Okay, pass over. Office to put up postal tracking report regarding notice issued to respondent. All respondents. No, now you appear for all the respondents except R1. Good. So who are the LRs of R1? Who are the LRs of R1? Huh? We will have it next week. Let us hear. We'll hear it. We'll hear it. We'll have it on Wednesday. By then you give the details of R1 also. Next day you'll be ready. And so the interim prayer there are. We'll hear it. Now what has happened now?
She's a really lady here. You are investigating her. She's very awesome. How I learned from the hand. The property, exactly the property, my property is different and the credit property. They're seeking my lot. I don't know, they're seeking in the same thing, my property is 372 bar, 372 my. They kindly have it completely.
Now, just one. I'll hear it and fix a day. You get ready. Meanwhile, if it is so that they have put up the construction, just wait. If it is so that they have put up the construction, we will only clarify that they will not create any third party interest and whatever construction that is done will allow them to complete. They will not claim any equities. We'll ask them not to create any third party interest and then let the suit proceedings be expedited. I'll have it. What I'm saying, think about it. So what I'm saying is, if it is so that they put up the construction, it has come to that stage, we'll ask them to declare that in the event they're going to lose the suit, they will not claim any equities. They will not create any third party interest. Let them complete it, and then we will expedite the proceedings in the suit. And this we can take it up at a later date. Let us get instructions. No, Wednesday will decide. Let him come prepared. Release the matter next Wednesday. Learned counsel so and so undertakes to file wakalat for respondents 2 to 6. And insofar as one, you give the details of who the LRs.
Sangamesh RB.
No, 115. Is it maintainable or not? Hello, maintainability pass over ಅಂದ್ರೆ ಏನ್ ಬಂತು? Senior ಅಲ್ಲ, ನೀವೇ ಹೇಳ್ಬೇಕು. Now take the file. File ಕೊಡಿ. ಅದಕ್ಕೇನ್ senior ಬೇಕು? Now you take file ಇಲ್ಲ. ಮತ್ತೆ? Get the file, you only come. I don't want a senior for maintainability. Yes. You are the plaintiff or? Yes. So what is the order you are challenging?
That has been already been adjudicated. In the second, already they have filed a suit. Said suit has been dismissed. Page 116. Oh yes, that's not to be.
Now the present suit is 7128.
Okay. Thank you.
7587 of 2011. Same parties. 2011 suit for partition.
Yes, only one property.
168/3 and 169/8.
Only one they are claiming the right in 168/8. Not in respect of 169/8. First, now, can you refer to additional governor 160? But here the property there is 7/177. Fire interest 126 dollars. Also 7 136 dollars. First, prior shortfall in that suit is for partition, as for cancellation of the executed by defendant number 2, favor of defendant number 6, and permanent injunction, and for partition.
Yes.
Because that suit was dismissed on 13/3/2019, page 229. Operative portion is at 145.
Yes.
Suit is dismissed. Cost, realistic cost of rupees 25,000 payable to the DLS. First, now after dismissal of that suit, now application for amendment is filed to include this property along with other two properties.
Show the proposed amendment.
First, page 153, annexure H. First, page 154 is the proposed amendment. Including all these. The suit item is at page 158. 177. Also, they include other two properties which are already been delineated. Where the defendant had purchased this property, father has purchased this property. And these are also part of the same thing. So, here I Petitions are being filed, detailed petitions are being filed. However, when we refer to the order, one and granted, allows the application without assigning any proper reasons for. Reasons is at page 206 for us. Reason is that the benefit of maybe to avoid certain technical aspects, numbers of paragraphs of the same along with the inclusion of others.
Page
206 reasons. Point number 1. Indians are bringing to amend certain technical aspects of the numbers of paragraph of the claim along with the inclusion of others as para 9A as 9B in the claim. Now, plaintiff states that the schedule B, D, and E property.
Okay, now what is the interim procedures? 2011 suit.
Overall, this property been divided. So the levels. Property is already been divided. Still, because of that, but in order to allow these differences, this should have been fine. But there are several suits pending before each party. These are being subject pending.
Note of the contention that the High Court has allowed the amendment application whereby inclusion of property bearing survey number 177 has been permitted, whereas as regards the same item of property, suit was dismissed between the same parties in verse 7128 of 2017. Subject to further consideration, for the stay of proceeding before the trial court in the next day. You should notice same now. Learned counsel for the petitioner submits court fee has been paid, office to verify. Which is the seal number? Adukuru. Yes. Yes.
The order of the crime, showing the real number. Here 6 was 5 or 11 in most cases. That is the different. Audited income tax returns. Years 2001. We oppose the application.
It has been allowed.
Another idea number. Yeah. Setback the agreement. Already. The solicitor verify whether any document stamp paper or not. But here, please. Document was. Is the just another. Here the after that it was marvelous. Again, this stage, even before the application, the document, the service that has find out the genuineness.
Please read the impugned order. Yes. Now you appear for the plaintiff. Yes.
Yeah. Having sorry. That is how we put a bit in the I will suggest that already other
No, but how are you prejudiced by that? He will tell if it is so or it is not.
This entire document sent to the FIR and return the stamp. Stamp not also. Thereafter, it has been marked. Now, once again, to send back to verify whether it has been imposed or not. When they see the application also, see the efforts to impose, there was no imposing on expert people.
It is not a stamped document, a stamp.
It is.
Document sheet.
Document sheet of this.
So according to you, even otherwise, it is of no value. It doesn't matter. It doesn't matter. Okay, what about the other IA?
Is only to.
What objections you have for that?
I have paid 31 lakhs but the dependent contents that 31 lakhs was only a loan amount, not funds for sale of this. Its contention is only a loan. But for the purpose of showing that I had the capacity of paying the balance amount, I have produced already the for the accounts.
No, maybe, but you will not be prejudiced as such.
It's not the person of legal requirement, legal requirement. But even if it is, burden will be on the plaintiff. Comply with the requirement of balancing. Now the advance rate is already
Admitted.
only the balance still consideration, whether I have the capacity to pay or not. I have already
It is submitted on behalf of the petitioner that insofar as order passed calling upon the plaintiff to produce his income tax returns, it is submitted that the bank statement is produced to indicate availability of funds to meet the obligations and the agreement of sale and obligations to meet the obligations under the agreement of sale, agreement to sell, and that the question of production of income tax return is of no consequence. Insofar as the order passed referring the matter, referring exhibit P1 to the office of the sub-registrar, it is pointed out that the said agreement was executed on document sheet. Accordingly, no occasion arises for examining the genuineness of the paper on which document has been executed. In light of the same, we stay of the impugned orders. Issue notice. Office objections to be complied with in the interregnum. Now, both of them are as against two IAs. Adu, one sentence. WP 3044 of 23 called along with the WP 3120 of 2023. And the first tail data, among common order.
What's the matter? Number 4.
Please, list the matter next week. No, now you take up.
Meanwhile, they have not created any third party.
So this is a number 8. This is an amendment, isn't it? Huh?
Don't making me as a party. Not in compromise. The compromise dictates. But I am the adopted for Allah. Through the registered adoption. Page number 49, election. Election.
Now you are not a party to the.
I am not a party. But I want to RCT or financial year. Plain copy also produce annexure. It is page number 22. I am not a party.
Now you are the.
Page number 39.
So who is the second defendant? Second?
Okay. Create third.
No. Are you not the second defendant? Page 24 is the cause title of the suit.
First defendant is his father. Rightly one second defendant absence.
No, the petitioner number 1 is the second defendant.
Yes, you are.
Now the second plaintiff, second petitioner is the third defendant.
Yes.
Now compromise entered into between whom?
Plaintiff and the defendant.
So then why do you say you are not a party?
You are not myself is maximum. Have the adopted.
No, but petition is filed by defendant 2 and 3.
Yes.
So where is Narsimullu?
That will bring copy to the election game, election B.
Yes.
And compromise security card and you are also election A. The page you are also being 24. Every copy is the election.
This one. This one. The next Sharia course. Annexure A is the order on amendment application. Annexure A, Nodi? Annexure A. Annexure B is sari ಇದೆ. A annexure A tally ಆಗಲ್ಲ.
Annexure A is challenge. Annexure B.
Annexure A is the order.
Yes. Annexure
A. So page 21 is the order passed on order 6 rule 70. How though? That is my notes also I have written that only.
Page 24.
In the tally agala. Page 24 is the plaintiff. Annexure A is the yes. I'll just pass over, just look at it. I'll pass over. Huh? Referee 328. Nam sari the nim tappu 328 WP, and that is the. Please check pass over. Check ಮಾಡಿ. Where is the con? Huh? ಬೇರೆ ಫೈಲ್ ತಂದಿದ್ದೀರಾ? ಅದಕ್ಕೆ ನನ್ನ ಹೋಮ್ವರ್ಕ್ ಟ್ಯಾಲಿ ಆಗ್ತಿರ್ಲಿಲ್ಲ. ಎಸ್.
Again, 33. Yeah, Ramesh.
To see where the other side is. I'll pass over. If he's there, bring him. Huh? Date code. Yes.
34.
Yes. Now you appear for the contesting respondent. आइए. Present writ is filed against. Now you who appears for the in the other matter? 24 and 26. Let us see what is the matter. Page. No, you are the plaintiff or the defendant.
Outside of the bench there. Also filed is for partition. She died, and LS 1A, B, C, D, E came on record. Now what has happened is, IA number 24 was filed by 1B and 1C. To transpose themselves as independent. Their attention is 1A. That is Nagaraj. That is the brother of the 1B and C. He sets up a will saying that Timaka has made a will his mother. According to that, all the properties will be complete text of him. While that is 1B and C, they make an application for transporting themselves. And as your lordship pointed out the other day,
I have forgotten what happened the other day.
Petition, what happened?
No, so just one. So all properties have been bequeathed to Nagaraj by Timmaka as asserted by them.
Have nothing to do with it. My submission is, if the internal dispute between the legal heads of Timmaka and Timmaka, if they have left a will, they should find it out in a separate independent suit where this right can be adjudicated. This is a suit merely for a partition. Therefore, Your Worship, IA 24 cannot be allowed because by transposing themselves as a defendants, they may file a written statement. Then the scope of the suit will be so much enlarged. Actually, that should be decided in a separate suit among themselves. Therefore, IA 24 is to be dismissed, Your Lordship.
This is
No, what? Now you appear, isn't it? No, correct. Now, how does it matter if both of you, if there's no objection, one of you do for R1D, one the other will do for R1E. There ends. Right. Let us see what the matter is. If it requires adjournment, I will.
Then 2 more cases. There are 20 only.
Yes.
Legal representative not conducting legal proceeding only and does not offer a dispute at all. Interstate dispute between the rival legal representative has to be independently tried and decided in a private proceeding. If this is allowed to be carried out for a decision of an eviction or other allied suits, delayed and by putting in it.
Yes.
Here also will was set up everything, Your Lordship. His Lordship says the internet dispute you work it out in a separate.
Now the original dispute,
Yes, Your Lordship.
was between Timmaka and the defendants. So what is the case between the plaintiff and the original plaintiff and the defendant? What is the original case?
The original case is for
Now,
partition.
Timmaka died subsequently.
Yes,
So the original dispute was
for a partition.
between Timmaka and
Defendants.
what is the relationship?
The relationship is not as than nothing that have a third degree. Disease, already a partition. There were two brothers. One brother Natapa was there, and the legal representative. These are heirs of Natapa. Natapa acquired opposite property by separate property. There is she can't claim that is the. Anyhow, it is a suit for partition. If Timmaka gets a decree in this, That they can work out all the legal issues.
amongst themselves. Now what? Now take me to IA 24.
I will look for it that.
Page,
Yes,
order at page.
I will read that. You will also get it at page 40 to 43 is the application. If the order on that is will also wants it, you will also get it at page 63, 76. All the three IAs are considered. I will read it, you will also. The application, page 40 to 43 will not. Read application.
That is under order 1 rule 10.
Yes.
Yes.
For the reason and in circumstances stated in the application, the application is of only and C and both them as both prevention. Speaking that fraudulent life. I submit that I am the allowed only of plaintiff in the above case and I am just as such, I am competent to make the subscribing law of other legal care, but it is allowed other ones, who is none other than my brother and facts in law of one state. I submit that the original plaintiff is expired or dead, and he being one of the legal representatives can take content. If they are included in the legal case, I submit that recently I came to know that the law number 1A Act is not but only and same with the explained regarding the law number 1 is chief examination. To my surprise that during my lifetime of my brother, that is, without our knowledge and consent, he got in dealing the same is initiated by fraud to destroy our interest for using property. My counsel has narrated the consequences. Not challenge the same as per law, and as such we are not in the knowledge of the arrangement. I submit that myself and my brother in the law number 1B and C of the development. We have been transposed as one of the students to college bill, produced by the law number 1A of the plaintiff to protect our interests since the
Yes, now you come to the order.
at page 63. Can I read only reasons?
Yes.
67. Here is to be had a reflected for partition for ethical and for rejected dated by a now is I looking filed by the LR C LR B1 B and C requesting them to transport them and arrange their arrange dated 1660 B and C. So here the events of LR B and C that they have in place as a lot of cities then the rights LR B to arrange 1664 not at all existed by the child. The mother of LR of the planet, therefore the LR will be weak. About the arrangement containing that it is created and recorded by LR.
Yes, just one minute. Now this application is filed by you.
Or when B and C have filed this application.
1B and C. Who appears for 1B and C? No, correct. Now, who appears for R1B? Now, who appears for R1B? Okay, who appears for the plaintiff? Who appears for the plaintiff? ಏನ್ ಮಾಡೋದು ಅವ್ರು ಯಾರು ಇರ್ಬೇಕಲ್ಲ. Huh? But if they don't present, then we'll proceed to pass orders. Why we should wait? 2020 matter. That Tuesday will not come because we will say election matter. It won't reach. Next date, the file will get lost. Election matter will be taken up every day till it's over. We'll have it on Tuesday or Wednesday. That's what to do. No, Wednesday.
The application is.
Correct.
They will not affect because they are the effects.
That amongst themselves, they have to. There is one judgment on that point, which says that inter se they have to do it in a separate proceeding.
They right, so I can understand if the right is going to be affected.
Wednesday, let us relist the matter in Wednesday. Same stage. On top of the B group list.
Prashant Priyan.
Yes.
Was filed by the plaintiff for the opponent hearing. Very interesting. That's what came to be discussed.
Page?
Other correction key, page 46. Page 46.
Between the same parties.
Same party. For injunction was filed. First issue was about issue the title. Accept. In 51. First issue the title. Because mentioned so frame and the titles also basically the dependent the plan and the petitioner here. Who came to petition this at page 69. 69. At 67 or at 1. The court told that the plaintiff has not proved title possession of the property. Plaintiff and appeal Nari, page 79 about section B. Page 79.
Now, what is the order that you are challenging?
The order direction came to the restricted. I come there.
So, if it is so, then you have to file a CRP, not a writ.
What is the issue?
No, correct. That's like, just take me to the impugned order for a minute.
Section K. Section K.
Yours.
The taken as primary issue. The court hold that developing the RSA was withdrawn, the liberty file fresh. Based on the evidence of the court. The court said that though it is indeed a restricted data, of this RSA, the court should just restricted.
No, correct. But the remedy is by way of a CRP, not a writ.
Easy RSA. It was withdrawn, not a suit. The third amount because of the suit and then not the amount submitted. These were take out order dated for the party. Party was fine was challenging that order. Accepting the order is here.
Correct. What I'm saying is, writ is not maintainable against the impugned order. It should be a CRP. No, correct. And so- There's no stay granted, is it?
There was an issue that happened. The lot was the RSA code.
The petitioner. After hearing the matter for some time, it is noticed that as against the impugned order, no, but what will now in the event this order is reversed? Let us see, we set aside the finding on the preliminary issue. Which suit? This suit. No, correct. What I'm saying, suppose this order on preliminary issue holds that it's barred by res judicata, then the suit will come to an end.
And I'm going to make an effort in the RT law, say that RT cannot be withdrawn, the memo, under 23 rule 1.
Now, that's a different matter. But this question cannot be decided as a preliminary. Under order 14, how you can, mixed question of fact and law, how you can decide as a preliminary? Saying that it can be. No, that's okay. Annexure? Page?
126.
Paragraph?
Paragraph 20. Under the concept of the 19.
21 is with respect to the defendant. 23 is another different rightly read on Taylor 2018 year 21. Second moment, they should remember the government of the bill and hand to the parties have already read again. I don't know that I don't know the parties have read the evidence. What happened along in the previous subgroup along, what is the intention to be there? Number one for other item numbers.
I'm not very sure if this can be done. We'll see. The counsel for the, after hearing the matter for some time, counsel for the petitioner files a memo. It seeks for conversion of the writ petition into a CRP. Same order. Matters disposed for statistical purposes. Petitioner is permitted to convert present petition into CRP and carry out necessary amendments in that regard. Next, in light of the contention raised that the proceedings have been adjudicated at an earlier point of time in OS 257 of 2002.
That is the right. Page 100.
275 of 2013. And that question of re-agitating the same in the present suit does not arise. There will be a stay of proceedings before the trial court. This interim order will be in force for a period of 3 weeks, within which petitioner to obtain appropriate order in the CRP. So you appear for? Yes, read out. You're reading at page? This suit is filed by the plaintiffs.
On principle, state and it of 1997 appears that it is also different one are the director of horticulture and the secretary of government of Karnataka and different are also made both the property. Therefore, it is proper and necessary to direct the painting. Present to increase
Now let us have a look at the plaintiff, verse 267. Now produce it. Let us have a look. Let us have a look at it. No, that's a different matter. Let us see what OS 267 is. If it relates to the same scheduled property, then how you can enter into a compromise? That's it. That we'll see. We produce it. This is the matter next week. And date. No, that's a different matter. Yes. You serve the government advocate. AG is directed to accept notice for respondent 1 and 2. This is the matter. What have you challenged? Page? Page 104. Yes. Having advanced the matter, no, so now we'll have it next week. You serve the government advocate. Now, instead of execution, here only I'll ask him to pay the money. Relist the matter next week. AG is directed to accept notice for respondent 1 and 2. Let us. No, you serve on the government advocate. Next week, we'll fix a date. In their presence, we'll ask them, if unless they have obtained stay, we'll ask them to pay the money. And date.
Pending. General 42.
I appear for the petitioner, my lord. Sorry, my lord, I was there in the morning session.
Respondent,
Respondent, I don't know, my lord. Two applications were dismissed. It's a commercial suit.
we'll fix a date next week, what to do. Or I can pass over, if the other side comes, I can take it up.
Anyhow, our interim order was passed not to precipitate the matter. That's why.
Interim order earlier granted, extended till the next date. Relist the matter next week.
Much obliged.
43.
Lords, I appear for the petitioner in this matter.
Yes.
Lords, the challenge is to an rejection of the amendment application that has been filed, Your Lordship.
Who appears for the other side?
Other side, I contacted the advocate. It appears he is not keeping well, my lord.
Then we'll have it next week.
Lord, the matter is listed before the trial court tomorrow for defendant's evidence. This application was filed at the time when the examination in chief of the plaintiff had commenced.
On what ground the court has rejected?
My lord, the trial court says that the proposed amendment changes the nature of the suit and a new cause of action is tried to be introduced, which is not the case, my lord. My lord, only 2 paragraphs have been added, which are in further explanation to the pleadings in the plaint, and they were based on some additional documents, my lord. Those documents have now been accepted by the court and marked in evidence.
There would be an interim order of stay of further proceedings till the next day. Interim order to be enforced for a period of 3 weeks. List the matter next week.
Grateful, my lord.
44.
My lords, I appear for the petitioners in this case, my lords. This is a matter wherein in respect of a bank guarantee which was offered as a security on a section 34 appeal by the respondent. My lords, totally 60% was to be covered under by way of a deposit, 40% by way of a bank guarantee. My lords, the court, while dismissing their petition, had granted liberty for me to withdraw the amount which was in deposit. In so far as a bank guarantee, since it was given during the course of section 34 proceedings, I made an application saying that I'm invoking the bank guarantee because they have not challenged this 34 order. They have accepted the order. So I'm entitled to the 100%. The learned trial court, my lords, passes an order on my application, which is at page number 132, my lords, of this. Has my lord got it?
Yes.
Lords, based on the application which I had filed, my lords, they say, the learned trial judge says, please go before and execute the award. My lords, this is not something, the bank guarantee was given as a part of the security bonds. And I have also produced the order asked by the learned trial judge while considering their application IA number 1. That is at page, my lords. The earlier order, my lords, during the course of the proceedings, that is at page number, it starts at page number 34, my lords.
Yes.
There, may I read it out, my lords? IA number 1 filed by the applicant petitioner, that is the respondent herein, is allowed. The operation and enforcement of the award.
And just there is some, which annexure?
My lords, that will be at page number 34, my lords. That is annexure.
Yes,
B.
page 30, yes, page
34.
32. That
32
is the order.
is annexure B, my lords. It starts at page 32. And then at 34 is the order, my lords.
There is some page.
Oh, I'm so
doesn't
sorry.
tally.
Pardon me, my lords.
Now
It is on
read that order.
IA number 1 filed with the applicant petitioner under section 636(3) of the Arbitration and Conciliation Act is allowed. The operation and enforcement of the award dated so and so state pending disposal of the main petition, subject to the applicant petitioner depositing 60% of the award amount and providing security for the rest of the 40% of the award amount within a period of 30 days from the date of this order. The deposit amount shall be kept in fixed deposit in State Bank of India for a period of 6 months with renewable clause. But subsequently, my lords, the court on 30th of October 2021 was pleased to dismiss their petition under section 34. And in the operative portion of the order, my lords, at page number 82,
yes.
Petition under section 34 of the Arbitration and Conciliation Act filed by the petitioner is dismissed. In the circumstances of the case, there is no order as to cost. Rupees 4 crore 80 lakh 2,855. It is kept in FD be released to the claimant along with the accrued interest after appeal period is over. Accordingly, I have received this particular amount, my lords. Then I make an application to the court for release of this particular amount. Was given by way of a bank guarantee and which was with a registrar, in the name of the registrar. Lords, when that application came to be passed, my lord, or filed, my lords, the court, after considering my application, passed the order at page number 132.
Yes, read.
This application is filed by the respondent praying invoking of the bank guarantee dated 7/10/2021 issued on behalf of petitioner and disbursed the amount to the respondent. It is stated that in this petition, as per the order, petitioner had furnished bank guarantee of rupees 4 crore 80 lakhs. The respondent has stated that as the petition is dismissed and judgment is not challenged by the petitioner, the respondent is entitled for this amount. The application is opposed by the petitioner stating that the court has become functus officio and no such order invoking bank guarantee can be passed. The petition challenging the award is dismissed. The bank guarantee was taken at the time of passing order staying the operation of the award. When petition is disposed of, the stay also stands vacated and there could be no stay.
Just hold. Yes, what you say. Now don't stand on technicalities. If you have to pay the money, you have to pay the money. No. Come, you can't say that. You have suffered a order. Now that has become attained finality. Then what is the great thing of not paying? Have you challenged it? Which one? This commercial appeal 1 of 2020 has been challenged.
Lords, I have challenged it only to the limited extent, my lords, of whether it's the revenue I'm entitled to or the profit.
Just let her complete.
When the award is no, it's not the bill. Bill does the award. if it was like us to arise, if you want to secure the amount that they are paying, the application we security bank guarantees, why it only costs in the order. If you never intended that amount is allowed to stay. In fact, if I make this, and this is for the here, what at least come from there. Why he is arbitral tribunal. That bank guarantee is already made absolute in favor of the petition. We have not taken place. In addition, there will be a possibility. It's going to be order of being we are only trying to circumvent.
But no, that's not the issue. If you had not filed an appeal, let's see. We'll have a look at the appeal papers. If they have not filed an appeal, then you can't raise a technical contention that no, you should go and file an execution.
In fact, even as against the bank guarantee, you should be an absolute under the arbitration. We are trying to remove that as well.
Let us see. Have you produced the appeal papers? Have you produced?
Yeah, I have produced the appeal, my lords. I have produced it. That is at page number, Annexure D at page 83. My lords, my appeal is only in so far as the fact as to whether the award I had sought for 10% of the revenue. What has been given to me is 10% of the profit. So only
Yes.
to that limited extent. But even if I fail that, I am entitled to the amount under the award because they are not telling the section 34 award, the order.
The scope of appeal is limited to
Only to the extent as to whether I meant only to the extent as to whether I am entitled to 10% of the revenue as per the terms of the contract. What the arbitral tribunal has granted is 10% of the profit. Revenue, gross revenue, and profit are two different aspects.
yes.
There is a page number 5. We
Next. Next.
even if that is the case, we would have to this is the main issue here.
Let's see. Now that you clarify, what is that amendment application you just place on
The
record?
amendment is, by mistake, they said set aside the impugned judgment dated. No, my lords, only in so far as it awards profit and not revenue. I'll place the amendment, my lords. I have the amendment application. I've already filed it before the division bench, commercial division bench.
Because they want for the security, they need to see the amendment.
That is the amendment.
Okay. No. No, now your liability has become final. So that you place that amendment, you place that amendment on record.
Place it, my lord, from ourselves will make that.
Yes.
I filed the application, my lords, it's there because by mistake this was done. My lords, the point is, my lords, I'm only saying whatever you have suffered by way of an award, which you have not challenged subsequently, it has attained finality. Please give me that money. It will not in any way change the scope of my appeal.
You're correct, madam. Now, what is your defense? You have no defense. So these are technical. No, those are technical arguments. I'm saying there's no defense. Liability you have suffered. You have not challenged that. Now let's assume that he withdraws the appeal. Let's assume. Then the award becomes attains finality.
Then we will inform the entire amount.
But even if his appeal is, let's assume the worst scenario, that his appeal is rejected, then the award as it is would stand affirmed, isn't it? They are seeking for an enhancement of their entitlement and not anything, anything lesser than that.
Yes.
And then they're only partial and if that has to be decided, therapy cannot be release of money. It will essentially be the court below exercising powers from the.
Let us see, but these are all technical arguments. These are very technical arguments. If you have to pay, if you have to pay and you have not challenged it, finally, then you have to pay. It will be Christian. Correct. The amount will be more than what they have claimed. What has happened before the tribunal and under 34, it can't be lesser than that.
Yes, absolutely.
Let us.
Well, that's my only concern is, my lords, this court had directed them to extend the bank guarantee by 8 weeks. The bank guarantee will expire at the end of February. If the matter can be taken up on Monday, my lords, I'll place that application also, which I filed before the court.
No, correct. Now they're raising some technical contentions for which we may have to hear and then pass some orders.
On Monday, my lords, if it is.
Then you come with whatever legal authority you have, but equity is not in your favor. Yes.
I appreciate that.
The counsel for the respondent submits that the bank guarantee would be extended by a further period of 12 weeks. 12 weeks. List the matter next week on date. Just search for any authority, any legal authority.
My lords, I have something, my lords. I'll also place that, my lords, because these are all securities given pursuant to a direction in an appeal in a section 34.
No, only a contention they're raising that there cannot be in an appeal, matter may have to go back after award is set aside. And there cannot be
I don't want the award to be set aside. It's only to say whether I'm entitled to profit or revenue. It can only increase. It cannot go back below that.
Let us.
Very well. Lords, 13th, my lords, if it is.
17th.
17th. 16th, I'll take a chance.
Yes.
45, Roman PS.
Yes.
Was filed on 16/11.
You are the? Yes. This is the order that you have challenged.
CH-11, the suit was filed. And the trial court heard the arguments on A1 and reserved for orders on 17-1, 17-11. And 17-11, the next party in was granted. One and came to the respondent issue. And that was 30-11 and 22. On the same day, the trial court, on submission of the defendant 192 appears and undertakes to file wakalat for defendant 192. Also undertakes to file written statement on behalf of defendant 192. On the same day, the trial court suspended its order and issued 2 summons to defendant.
Who appears for?
I appear for respondent number 3 in this matter, my lords.
But how can this be done?
Your lordships have page 21 and 22.
Yes.
But the no doubt heard on 16-11 and reserved. But it was posted on 17-11 for pronouncement of the order.
Where?
Page 22, if your lordship sees, I think page 22.
Yes.
The order was not signed. Before it was pronounced, but we move the code. 17-11, you see, the handwriting is called at 11. In page 20.
Yes.
It was never signed or pronounced. It was kept ready. Case called at 11 a.m. Party order. This ensures the responsibility.
Correct, but once the court hears the matter and has a
It had reserved. I can understand if it had pronounced and then recall it. I can understand the issue. But it was not what pronounced. It is kept in the file.
no, but when court has made up its
It's not that.
correct. Once that is done, then question of altering that order after your appearance on the next date would not arise.
The lordship sees. It is not that the Lord's orders are reserved. It is not pronounced. But then the Lord, if somebody moves, a re-hearing or something, but if it is time, actually this order not have gone this. Because it's not signed, it's not even a signed order. Because signed order, you can understand it becomes a order. The Lord is signed order. Till it is pronounced and signed and pronounced, there is no order in the area. All the Lord will only serve. We have made our leaders. Now let's be there in the worst time. Yeah, house. Operation is later. But instead of keeping this pending here, within 15 days, let the court decide after hearing others. Now, please see what it takes. Please think of the level of it.
No, what is the status of?
Now there is a status quo order operating like this.
So then we'll do one thing. We'll continue that status quo order and direct the trial court to dispose it of within a month from today. No, we will clarify that it's only for, and we keep it open.
Yes. My problem is.
Yes.
He himself admits the petitioner claimed is no longer in possession of skills. The government wanted to claim to the owner of supplement level over related to this property is property to agents that
Anyhow, we'll ask the trial court to dispose it of within 30 days from today. And the status quo order will be in force till that date, while making it clear that we have not expressed any opinion on merits of the matter. It's the we don't. Let's see. We'll see. The petitioner has petitioner of the plaintiff has sought for setting aside of the order of 17/11/22 passed in verse 621 of 2022, whereby the trial court, though has typed out an order granting ex parte injunction on IA number 1, not having signed such order as upon the request of the defendants and their appearance, clarified that the ex parte order printed on the order sheet stands suspended. Next. It is noticed that the trial court, after hearing the plaintiff on 16/11, had called the matter on 17/11 for pronouncement of ex parte order. The records indicate that ex parte order on IA number 1 was drafted and printed, though not signed. Signed and pronounced. In light of the defendants having appeared, court was of the opinion that an opportunity could be granted after taking the written statement into account, and accordingly has suspended the ex parte order. Next. It is after having heard the matter for some time, it would meet the interests of justice if the trial court is directed to dispose of IA1 within a period of 30 days. Until then, the order of interim order granted by this court would continue. It's clarified that the continuation of the interim order is only a temporary arrangement and would not come in the way of the trial court taking an independent view and passing orders on IA1 as it may deem appropriate. Accordingly, petition is disposed of. Next week.
46, my lord.
Yes, yes.
I am appearing for the
Yes,
petitioner. But in this matter, in the second matter, my learned friend may be directed to take notice.
You will
So,
accept.
sir, I will, and it may be called next week or convenient day, my lord. So
Yes.
it's a short question, grant of injunction, whether right or wrong.
Let us. The council so and so accepts notice for the respondent 1 and 2.
One minute.
Delist the matter next week.
Date may be given, madam.
Yes.
I'm for the petitioner in this matter, my lord. 47, I'm for the petitioner, my lord.
Yes.
Lord, this matter was listed before the court 2 days ago, and my lord had directed the respondent to serve a copy of those gift deeds on me, my lord.
Have served.
I have been served yesterday, my lord, and a perusal of the gift deeds will show a different scheduled property to the suit scheduled property.
Now we'll see it. We'll admit that whether it is or not. We'll demonstrate it. Please fix the date next week, my lord. I will argue.
List the matter next Wednesday.
My
Next
lord,
Wednesday.
a moment, my lord. My lord, on the previous occasion, my lord indicated that if it was served, the trial court could consider the application afresh.
Then let
Now,
him
if-
come. We'll hear it. We'll hear it
Very well,
and
then-
dispose of the matter. We'll
Yes,
have it on next Wednesday.
I'm obliged.
Yes. List the matter on. Yes. Do 48 and 7.
48 and 7.
Right.
Order part of the matter.
Every petition has happened in this case in 2016. This is dismissed.
Just one minute. Now, what happened? Have you served there? Yeah. You have served. What is the order?
Page number, the history number, the page was operated. Action order is not in the
Yes. You have a typed copy, or? So which date you take?
Page number 95.
Yes. You are the plaintiff. Yes.
Plaintiff absent, entire units, or entity of the said document remained absent. So this distinct for not. Two documents being as follows. The office shall send to the deputy commissioner on the document and the revenue authority collect the penalty on the document. But this order is passed. Before this level, there is a hearing on admissibility of the document. On which no orders are passed. The suit is written for non-consumption. Then allows I come before allows I file an application for setting aside the expiry. The order is then set aside. After that,
No, but on 11A, in the typed portion,
I just read from the actual.
yes, you should pay a typist well. Page, now take me to the.
Plaintiff absent, no representation when the case is called off at 11:40 AM. The case is again called at 3:50 PM. Plaintiff is absent, no representation, in spite of sufficient opportunity being given. Plaintiff failed to convince the court on his admissibility and the suit document and remained absent, no representation. No representation and the plaintiff is absent. Plaintiff on main petition hearing and also sufficient opportunity. Suit is dismissed for non-prosecution. Suit document being unregistered sale agreement dated 27/9/2003. Office is directed to send the document to Deputy Commissioner regarding to impound the document, to recover the duty and penalty as arrears of land rent. Subsequent to this, I am not going to come over to the next page. First, we filed an application on 11/8/20. We are not realizing we filed an application on 11/8/20 for setting aside by filing a mistake. Mistake is may not be allowed. The matter then taken back on record. Then it may not be to know from. Because after several days of hearing, at page number 74, page number 74. It is forthcoming that on 29/8/2016 itself, the document was forwarded to the Deputy Commissioner, but till date there is no response from the office of DC. Hence, the office is directed to write an reminder Paid report from DC forward 29/8. Then there was case number 75. It is ordered to issue reminder to Inspector General of Registration of stamps with the direction to collect duty and penalty forward the document. Reminder is sent. Then
So now what?
thereafter, case number. Case number 21. Case number 21. How is the order sheet report? This is the office of case number 21. This is the office. It is forthcoming that the original sale agreement has returned to this court on 8/5/2018 by the district registrar without collecting duty and penalty. Hence, office is hereby directed to calculate duty and penalty payable on the sale agreement. Now, still now there has been no adjudication on whether the document is insufficient. Already a direct, several directions. Then, finally, on 16/11, on perusal of the recitals incorporated in the sale agreement dated such individual is liable to pay stamp duty as per Article 5E1, Section 20 of the Stamp Act. Hence, office is directed to calculate duty and penalty under Article 5E or as per office calculation, the document relied on the plaintiff is liable for duty and penalty for sum of 14 lakh. Plaintiff's payment, hence, I granted duty. Entire procedure which is followed completely contrary to law, but the direct judgment is not the court of decision. That same situation. According to the case of the petition, paragraph number 3 minutes, page 4. Page 3 of the order.
Yes.
According to the case of the petitioner, an agreement of sale in respect of scheduled property was executed on 27 July 2000, when we go for recording of the petition. Order dated 28th January 2000. I said order, the agreement was ordered to be informed, and the court was directed to calculate the stamp duty and penalty. The petitioner relying on the fact that on 5th March 2013, the report was submitted by the office of the trial court, stating that order stamp duty was paid in the state. However, on 3rd December 2013, on 9th January 2013,
go to para 7.
Stated earlier, under section 33 of the statute, and reading section. The report was an order. The learned judge must come to a conclusion that the instrument is not duly stamped. The result of the order dated 28th January 2000 shows that there is no finding recorded by the learned trial judge that it appears to him that the agreement is sufficiently stamped. Subsection 2 of section 33 provides a more important document. The court has to examine the instrument in order to ascertain whether it is stamped or stamped of relevant institution by the recording. Thus, the condition precedent for informing the document by exercising the power under section 33 the satisfaction of the court that the instrument appears to be insufficient. No such finding has been recorded in the order dated 28th January. The learned trial judge has directed the court office to calculate the stamp duty and penalty. It is not the problem of the court office to calculate what the stamp duty and penalty payable against what is approximate stamp duty is issued to be decided according to the Stamp Act. And for this, there is another judgment. How the Stamp Act was passed a recent judgment. It says that only the district registrar has to determine. Now coming to annexure A, it is an order directing the office to send the document to district registrar for collecting duty and penalty. This order completely overlooks the fact that there are terms of an earlier order and the same exercise. When passing an order dated 9 January 2007, as far as improved order of 7th October, it is stated that already.
Light of view contention by counsel to the petitioner that the trial court has not, at the first instance, passed a order coming to a conclusion that the document is not properly stamped. The subsequent procedure followed and eventual office note being accepted is contrary to law. Subject to further consideration, there would be an interim order of stay of the impugned order dated
Directing me to pay the
30/11/2022. Recently, counsel for the petitioner submits that the procedure relies on the order passed in WP 6911 of 2015. Yes.
pay the stamp duty amount. The penalty amount my lord said.
No, there's nothing in between, isn't it? You'll have to pay.
Even a second technicality, there is an amendment in the document saying that possession, the possession is actually delivered or not. The language of the document
These are not much relevance. Whatever is mentioned is that would bind. Let us.
on the issue of penalty. Because the value of the penalty exceeds the value of the properties. Because and it's being calculated by the office. But whatever are the circumstances, the district registrar has the discretion between.
So let them come with. Yes. Maintainability, some of this. That has been rejected. Okay, now, office objection. That is the point, isn't it? Office objection is overruled in light of this submission made by counsel for the petitioner. So you take out notice. Issue notice, same one. Yes. Let us.
Yes.
Other matters.
950 to 250 development. 950. Even.
Other matters, dates will be given. You can take dates of your convenience. Interim orders will stand. Yes. Serial number? Yes.
On the ground of a wrong court order. Day of the suit is when various arguments are completed. Defendant's argument He had been nominated as an indigent person. Elsewhere brought on also indigent. The order British and I, as the indigent person, have now as a super state, always on that matter. There's a conflict of judgment between but what we want. We make a security, stay with me, keep this force. But it is that is order to pay the force. You have to pay. If it is I will pay, keep the money in the force. That is my the main issue to take its time and the becoming from.
Miss, what do you say? No, otherwise we can do one thing. Now, even if you pay the court fee, we'll make it a conditional order. We will, if you pay the court fee, you pay the court fee, we'll make an order that would be subject to orders to be passed. Then let the proceedings go on. No, so then you can pay it. We will make it clear that the payment would be subject to outcome of the present petition. And then vacate the stay, let it go on. In the event you succeed to, or whatever, that, whatever, that no. So what we're saying, if it is so, then you pay the court fee. We would make that payment subject to orders to be passed. Either way, if there's going to be some adjudication. No, that we'll see.
My fee is my position. I understood. Because he on the she came to court, he had to pay the court fee. If he pays the court fee, the matter can go on. And if I don't understand, middle taking on deposit. If he gives them this is a
What happened before the trial court? No, yes.
in the pendency of the suit, right? Here representatives came on the court. The government ruling of our court says that the legal representatives their personal relief. The representatives come on the court, get a court fee, or file a proper application, seek exemption and independence. They have to pay the court fee. Rely upon the judgment of our. He has to pay the fees because he succeeds in the matter. I give him, I have to pay the cost. There is no, you know, giving that money. The objective of the system not proceed because the legal representatives haven't paid the court fee. Like on the second law is out of the court.
We'll have it on Monday. We'll have it on Monday. That is. Relist after when we are in a hurry. Like Monday. Interim order. Earlier grant is extended.